on a vacant lot in a largely built-out subdivision. Yet their home building plans remain on hold to this day because EPA remains steadfast in its view that their property contains navigable waters subject to regulation under the Clean Water Act. But under no plausible interpretation of that term does the agency have such authority. Now, the statute defines navigable waters as the waters of the United States, and so explicitly requires that EPA establish two things before it may regulate. First, there must be a water, that is, a hydrogeographic feature that in ordinary parlance would be referred to as a type of stream, creek, river, lake, or the like. A wetland, however, is none of those things, and so it can be regulated as a water only to the extent that it blends into and thus becomes indistinguishable from an abutting water. Second, the water has to be of the United States, that is, for all practical purposes, a navigable, in fact, water. Now, this test is vastly superior to the significant nexus test for a number of reasons. First, and most importantly, the two-step framework closely adheres to the textual limits that Congress itself imposed on the agency. Second, by faithfully adhering to those limits, the test faithfully vindicates all of Congress's purposes, not just its water quality purposes, but also its desire to preserve the state's traditional preeminence over land and water resources. And thirdly, it's an easy-to-administer test. Ordinary citizens can use their own eyes to reliably determine whether or not their land is regulated. And under this two-step framework, it's clear that the Sackett's property contains no waters, much less waters of the United States, and so they should be entitled to a declaration that their property is not subject to EPA's authority.
Mr. Schiff, can intrastate, purely intrastate navigable bodies of water be waters of the United States?
Yes, Justice Thomas.
And how is that, if it's purely intrastate?
If, as a statutory matter, if that interstate navigable water connects with some form of interstate transportation, such that there could be a continuous channel of interstate commerce, then that water could be regulated.
So what does that mean?
I'll give you an example, Your Honor. The Great Salt Lake. The Great Salt Lake is not a traditional navigable water, even though it's navigable in fact, precisely because it doesn't hook up to any other waters to flow interstate. But obviously there are a lot of forms of non-aquatic transportation that can get you there, and that can sustain an interstate channel of commerce. So that's an example of a water body that, though wholly intrastate, would qualify as a statutory matter as a water of the United States. So
why isn't that met here?
Well, Your Honor, there is no allegation whatsoever that the Sacketts discharge any pollutants into Priest Lake.
Well, I think the question, the issue would be if there is nearby a body of water that could be considered navigable, that possibly the wetland could be associated or connected with that in some way.
Your Honor,
I mean, you have a ditch, you have a body of water, and you have sort of a nexus with the land.
Justice Thomas, mere adjacency itself cannot justify the agency's statutory jurisdiction for a number of reasons. The text of the statute says, setting aside even of the United States, the text says that if it's not even a water, it can't even be regulated. And the plain meaning of water, as elucidated by dictionary definitions and what have you, is streams, creeks, rivers, what have you, not wetlands.
But doesn't that, Mr. Schiff, ignore the import of 1344G1, which really specifically says that when we're talking about waters, we're talking about including their wetlands, 1344G1 says. So if we're going to be fair to the text of the statute, isn't there a pretty powerful indication that wetlands are included, adjacent wetlands are included? And then we can talk about what the word adjacent means, but adjacent wetlands are included.
Absolutely, Justice Kagan. There's no doubt that some wetlands are in fact regulated, and the question is what kind of wetlands? Now, adjacency in the context of 404G clearly means physically touching. For example, if I were to say, I own 2 adjacent parcels of land.
Well, you say that's clearly true, but in fact, when you look to our normal indicators of statutory meaning, at first we look to dictionaries. And if you look to dictionaries, both legal and non-legal, what they show is that adjacency actually is not the same as touching or contiguity, that adjacency has something to do with proximity, of course, but the definitions are actually remarkably explicit about the fact that two things can be adjacent to each other without touching each other.
Justice Kagan, if I could respectfully disagree, certainly adjacency in the abstract can have more than one meaning, but in the particular context of comparing relationships between topographic features, as that word is obviously employed in 404G1, I think the only plausible understanding of that term is physically touching.
Well, why didn't
I'm not sure that's right. I don't know whether they're topographical features or not, but you would readily say that a train station is adjacent to the tracks, even though it's not touching the tracks.
That is right, Mr. Chief Justice, that is correct. However, the example that I was going to give is if I were to say that I own two adjacent parcels of land, I don't think anyone would just simply think that I meant I own two parcels of land in the neighborhood. But that necessarily implies that they're physically touching. And it's that particular...
Well, let me give you another example. I grew up in an apartment building in New York City. If I say there are two adjacent apartment buildings, do they have to be touching each other? Or it could be, one is across a side street,
Again, Justice...
I mean, I would say that those two apartment buildings are adjacent to each other because there's no other apartment building in between them, even if they're not touching each other.
Again, Justice Kagan, I would say that when we're speaking specifically about physical topographic features, natural features like wetlands and other water bodies, I think that physically touching requirement is essential and is the meaning of adjacency as used in 404G. That is, in fact, actually...
Mr. Schiff, isn't the issue what Congress would have intended with respect to adjacency? And there was a regulation that defined adjacency to include neighboring. And as far as I know, Congress used the term adjacency and didn't adjust it to try to make clear the touching requirement that you say was intended by the term.
Yes, Justice Jackson. Every single time that argument has been advanced by the government, it has been rejected by this court. In Rapanos, the plurality opinion rejected out hand the idea that 404G represents a ratification of the Corps' broad understanding of adjacency. Justice Kennedy's opinion doesn't even give it consideration. Swank, for its part, said 404G is unenlightening as to the meaning of waters in the United
States. All right,
well,
let me try to bring some enlightenment to it by asking it this way. You say the question is which wetlands are covered, which I agree with, but I guess my question is why would Congress draw the coverage line between abutting wetlands and neighboring wetlands when the objective of the statute is to ensure the chemical, physical, and biological integrity of the nation's waters? So are you saying that neighboring wetlands can't impact the quality of navigable waters?
Justice Jackson, not at all. However, it's also important to acknowledge that Congress was balancing concerns here. On the one hand, there is a water quality issue. But on the other hand, there's a very important federalism issue, so important that actually Congress put it in the text of the Act that one of the purposes of the Act is to preserve traditional state authority over land and water resources.
I didn't read that as a purpose. I mean, Congress said our objective is to address or make sure that we maintain the integrity of the waters. It was one of the policies in achieving that objective that we care about states' rights or federalism concerns. But I didn't see that as Congress's primary objective or even, a main objective with respect to the Clean Water Act.
That is true, Justice Jackson, although this court in Swank very much relied upon, however you would like to call it, this principle of federalism to adopt a narrow construction.
But, counsel, how can you say they wanted a narrow construction when they were very, very clear in the statute in 1341G that the corps couldn't give states jurisdiction over adjacent wetlands to navigable waters? You are not disputing that Priest Lake is a navigable water, correct?
That is correct, Your Honor.
It's 62 miles long. It carries people. It's an instrument in transport. That's the definition of traditional navigable waters. So as I see the question here is what did Congress mean by adjacent? And now you are saying it requires a continuous water surface. But how about a natural beam? Even the Trump administration, who came close to adopting your meaning, exempted beams. It exempted beaver dams. It exempted those two items, and they would stop continuous surface flow. So where does your definition come from?
Justice Sotomayor, if I could go back first to the first point about 404G, and also in partial response to Justice Jackson's question, even in Riverside Bayview, which is the only time that this court has actually upheld the agency's assertion of jurisdiction, even there, at most the court was willing to say is that 404G simply means that wetlands are not necessarily excluded from the definition of waters, but it wasn't even prepared to adopt a general affirmation of adjacency. In part, that's because none of the 1977 amendments had anything to do with the definitional text. And I think this is in response to your second question, Justice Sotomayor. Where does the test come from? Well, it comes from that unchanged definitional text. Congress did not change the term the waters of the United States. And a water is, again, in ordinary parlance, we would submit something that is other than a wetland. And the only way that one can plausibly regulate it is if one has, what was at issue in Riverside Bayview?
I'm sorry, EPA had, by that time, as Justice Jackson said, indicated that the term adjacent wetland would include wetlands separated by berms or dunes or man-made dikes or levees from the navigable water. Okay, so EPA, as of 77, had made that clear, and the term adjacent wetland explicitly made that clear. And then Congress uses the term adjacent wetland. And my understanding is every administration since 1977, but correct me if I'm wrong, has stuck with adjacent wetland includes those wetlands separated by berms, dunes, dikes, or levees from the navigable water. So why shouldn't we read adjacent wetland in the statute to mean what EPA had said, as Justice Jackson asked? And what significance should it have that every administration since then has included those wetlands as covered by this statute?
Justice Kavanaugh, in answer to your first question, I think, again, it goes back to the text, that if one accepts the proposition that waters, their ordinary meaning as employed by Congress, does not normally include wetlands, then that raises a textual difficulty. How can wetlands...
But in Riverside Bayview said the contrary to that. Obviously, it said wetlands are included. The statute refers to adjacent wetlands. EPA has said since 77 that adjacent means those wetlands, even if separated by berms, dunes, levees, or dikes.
Well, Justice Kavanaugh, I don't want to necessarily die on this hill because obviously the facts in this record are such that...
Let's put aside the facts of this case, because this case is going to be important for wetlands throughout the country, and we have to get it right. So why wouldn't a wetland separated by a berm, dune, levee, or dike be covered, contrary to what in the last 45 years have suggested?
In response to the second part of your question, Justice Kavanaugh, about the fact that the agencies have consistently interpreted this over a long period of time, I think Justice Scalia appropriately responded to that argument in the Rapanos plurality, where he says it's a sort of now 40-year adverse possession of statutory authority. So I would say the mere fact that it's been interpreted that way can't convert the fact that if one accepts that waters, as ordinarily understood, and not just in the dictionary, but in our yellow brief...
I would agree with that, but for the initial history of when Congress put that term adjacent wetland in, or I would think that has some force at least, but for that.
Can I ask just a clarifying question to Justice Kavanaugh's? If you could help me with the timing, because as Justice Kavanaugh says, you know, one argument that the government makes and that would have some force is that the regulation defined adjacent in the way Justice Kavanaugh is pointing out. What is the timing? Because I understand it that regulation was adopted in 1977 and 1344G was passed in 1977.
Yes, Justice Barrett, my understanding, and it was actually regulation from the Army Corps, not from the EPA. But the Army Corps had a series of regulations, and the final version was issued in 1977, I think shortly before.
So it wasn't like an old soil, it was pretty proximate in time to the enactment of 1344G?
I believe, Justice Barrett, it was about 1 or 2 months prior to the enactment of the 1977 amendment.
The act was December, and this was, I think, in the summer. But wasn't this discussed? The whole question of wetlands was a big part of the discussion in the 77 amendments, or am I wrong about that?
No, you're absolutely right, Justice Kavanaugh. And again, the Sacketts certainly don't dispute that wetlands are in fact regulated. But again, I would go back to Justice Scalia's analysis in the plurality opinion. One cannot read the legislative history of the 77 amendments to then conclude that every jot and tittle of the Corps' regulations were then affirmed. And in fact, again, I would go back to Riverside Bay.
There's even lengthier history. I mean, before the regulations become the regulations, there's a whole controversy about it, because the first Corps regulation was much more along the lines of what you were proposing. And then there was a big brouhaha, and the Corps was interpreting it too narrowly, and the Corps essentially changed its mind. And everybody was aware that this had happened, that the Corps first came out of the blocks with a narrow interpretation and, was essentially convinced to reverse itself on the theory that it was not reflective of what Congress had wanted.
Justice Kagan, I would say one answer is that if Your Honor is referring to, say, a failed legislative proposal, I mean, I don't think one can really put much...
I'm not really referring to that. I'm sort of referring to a story that I don't think anybody disputes about the history here, which is that the first regulation, the first interpretation is quite narrow, and there was a blowback, and the Corps changes its mind. And so everybody's aware on a sort of continuing basis of this issue. It's not as though the regulation came out and then the statute was amended all within a month, and nobody had time to think about this question. I mean, people had been thinking about this question almost the entire time in the interim between the initial statute and the amendment.
That is true, Justice Kagan, but I think there's a lack of commensurability here in that the relevant Corps regulation during this period that you note was a regulation purporting to interpret the waters of the United States. Now, it would seem passing strange, in my view, for Congress to say, we're going to resolve this lengthy administrative dispute by entirely ignoring the statutory text that the regulation that is cause of the dispute is related to. And instead, we're going to effect what amounts to a significant expansion of federal authority over land use by including in a parenthetical and a provision that deals with permit transfer a reference to adjacent wetlands. That seems to me just to be an unlikely way for Congress to effect what would be a significant unbalancing of traditional...
Counsel, in Schwank, we said directly, the 1977 amendment showed, quote, Congress' unequivocal acquiescence to and approval of the Corps' regulations interpreting the Act to cover wetlands adjacent to navigable waters. There we faced the question and said, at least as to that definition, Congress was clear. So my problem with your point is even Rapanos, Justice Scalia, recognized, whether it's scientifically accurate or not, that what navigable waters can be is anything that's adjacent to what we think of as traditional navigable waters. No one's suggesting you can put a boat on a wetland. It would sink. You can't put a boat of certain sizes, or many, near the shoreline because they would sink. There's not enough water there to hold them up. So I don't understand how the wetland has to be navigable. It does have to be adjacent because it's part of that river. And Rapanos suggested it's hard to tell where the beginning of the wetland is and where the beginning of the water is. Whether that's true or not is irrelevant. Congress defined the term as navigable waters and adjacent wetlands. So if I take that as their definition, why don't we say that something that is near qualifies? And so the question becomes, what's near enough, isn't it?
Justice Sotomayor, I would respectfully disagree. I think this would be a totally different case if Congress, in fact, had defined navigable waters as the waters of the United States plus adjacent wetlands, which is precisely what the core regulation was trying to do in the 70s. But Congress hasn't done that. In fact, it studiously avoided touching that central definitional provision for the last 50 years. With respect, though, Justice Sotomayor, to your point about why do wetlands have to be navigable? They don't have to be navigable. Certainly, in the normal delimitation of any water, you're always going to have a point at which navigability, in fact, towards the banks of a river, for example, is going to disappear. But that doesn't change the fact that one can plausibly define a river, say up to its ordinary high water mark, and understand that waterward of that mark, one might not have navigability at all points. And I think the same thing is true when it comes to defining the outer scope of waters with respect to abutting wetlands. That as one approaches the shore, it may not become physically possible to navigate, but one can still reasonably say that one hasn't yet completely departed the water.
But counsel, why is it that your conception of this does not relate in any way to Congress's primary objective? Do you dispute that the primary objective, as stated in the statute, I guess it's at 1251, is that Congress cared about making sure that the chemical, physical, and biological integrity of the nation's waters was protected?
Justice Jackson, we don't dispute that. However, no statute pursues its purpose or its objective at all costs. That the limitations in the statute are as much a part of its purpose as its affirmative authorization.
So why didn't Congress say immediately adjacent? If they were trying to achieve something different than what the regulations had said about adjacency, if they were balancing their concerns about protecting the integrity of the navigable waters with the property interests in the state's rights to control it, why didn't they say immediately adjacent in terms of the wetlands coverage?
Justice Jackson,
a footnote. Why didn't they use the word they used elsewhere, abutting?
Abutting.
Well, Justice Jackson, I don't believe the term abutting appears in the statute, but one reason why—
Oh, it actually does. Assume it does. There are other sections that use the word abutting.
Well, Justice Sotomayor and Justice Jackson, I would say with respect to the question of immediate adjacency, I think one reason why Congress didn't bother is because I don't believe Congress was at all thinking that 404G would have any impact upon the scope of the Act. Again, if Congress intended to want to definitively change the scope of the Act, one would think that the most natural move would have been to amend the definition of navigable waters.
But can I just, I'm sorry. You suggest that the balancing, that the limitation is about the concerns with respect to the state's administration, and 1344G is precisely where they're talking about what is left to the state versus the federal government, and in that statute, it just uses adjacent. So with respect, that seems to me to be exactly where they would have made clear that the federal government's scope of authority was abutting or immediately adjacent, and we're leaving the rest to the states under your own theory of what they were trying to do.
Justice Jackson, my disagreement there is that presupposes that Section 404 already regulates the universe of all wetlands, and that it's essentially a federal privilege whether or not any of that regulatory authority will be given back to the states. But I don't believe that that's at all what Congress intended. I think Congress recognized that, setting aside the Clean Water Act, there would be a significant swath of land use and water regulation that would remain to the states. And I think one good example to prove that point is, as we discussed in the briefs, non-point source pollution. Everyone recognizes that non-point source pollution is a serious water quality issue. But it's never been disputed that the Clean Water Act doesn't reach that, which I think emphasizes that the purpose of Congress in enacting the Clean Water Act was not at all costs, let's clean up water quality as much as we can. It was a balancing to recognize that some water quality measures, like wetlands regulation, inevitably, as this Act's case demonstrates, inevitably converts EPA and the Corps into land use administrators.
So can I just ask you, so the reason why, in your view, Congress includes wetlands or thinks some wetlands should be in there is what? Is it because they can't be distinguished, or because those wetlands affect the water quality of navigable waters?
Justice Jackson, I think the main answer is that precisely the rationale that Riverside Bayview gave, that inevitably, in delimiting any true waters, one will have to pick a point at which land ends and water begins, and in that intermediate zone there will be things like wetlands.
But if you read Riverside Bayview carefully, it looks to me as though we were talking about the Corps' rationale, not Congress's, that we were saying the difficulty of being able to tell land from water is the reason that the Corps thought it should or could include the abutting wetlands. But it doesn't suggest that that was Congress's reason, that Congress said something about wetlands because it would be too difficult to distinguish. So is there something in the text or the history of the statute that points to that concern as being one of Congress?
Yes, Justice Jackson, I would go back again to the definitional text, that Congress used the term waters. Congress knew about wetlands. Congress knew about how wetlands affect water quality, even in 1972. In our yellow brief at pages 4 and 5, we cite a number of examples in the years leading up to 1972, where Congress, in a variety of acts, explicitly distinguished between wetlands and other types of waters. So Riverside Bayview certainly adopts, in our view, the idea that waters are ambiguous when applied to the facts on the ground, and that ambiguity necessarily means that some wetlands will be regulated, and to justify that perhaps mild excursion from the text, Riverside Bayview noted the Corps' ecological judgments, that those judgments supported the categorical rule that where the line drawing problem arises, that is when Congress can regulate these wetlands as waters.
Mr. Schiff, let me follow up on Justice Jackson's question. 1344G is the biggest problem for you, clearly. Is your answer to Justice Jackson, she's pointing out that in the parenthetical in 1344G, where it gives the state, well, 1344G gives the state permitting authority but accepts navigable waters, essentially, including wetlands adjacent thereto. If we read waters of the United States as you propose, does that mean that wetlands fall in another world where neither states nor the federal government can regulate them?
No, not at all, Justice Barrett. I mean, certainly there will be many wetlands that will still be regulated, even if the court adopts the test that the Sacketts have offered, precisely because of this line drawing problem, that there will be wetlands that cannot be readily distinguished from adjoining waters.
But you're assuming you're oh, sorry.
Go ahead.
You're assuming the adjacent. You're assuming that we adopt your. I'll save it for my round. That's fine.
Counsel, thank you. We've been talking a lot about adjacency, but your test also addresses the question of continuity. Are you saying in your brief that there is no wetland if, for example, in a few weeks in July, the ground dries up and there isn't a immediate connection between wet area and the navigable water?
No, Mr. Chief Justice. I mean, we make allowance for this normal circumstances understanding that what should guide the line drawing standard application is what would in normal circumstances be the case. So,
well, is it normal circumstances if it's from the fall to the spring, but June, July, and August, you don't have that kind of connection?
If on a normal yearly basis there would not be a continuous connection, then I think it would be very hard to fit the wetland into the rationale of the line drawing problem standard, precisely.
And not simply in the area that's dried up, but you would say the entire area that is normally connected but isn't for 3 months in the summer, that whole area is not a wetland?
No, Mr. Chief Justice, if I understand the hypothetical correctly, it's not that it suddenly defederalizes everything, but certainly it's difficult to understand textually how one can regulate an area as a water if on a regular basis there is no water there. Much less.
Does the summer count as a regular basis? It just dries up in the summer. It's pretty common, I think, for wetlands, or at least adjacent waters in many situations.
Mr. Chief Justice, it's certainly a regular occurrence. And admittedly, this is one of the cases at the margin where I would say with respect to any legal rule, there's going to be difficult cases. And perhaps that could be reduced through further agency rulemaking. But I think what's important and what we haven't really discussed, which the court hasn't noted much yet, is comparing whatever shortcomings there may be in the line drawing problems test to the shortcomings that are orders of magnitude greater from the only other game in town, the significant nexus test. both in terms of its lack of fidelity to the text, in terms of its subversion of the federal structure, in terms of its much greater difficulty in application.
Thank you, Counsel. Justice Thomas?
Counsel, I'd like to just give you a minute to at least comment on what we have said about 1344G in Swank and what the court has said about it in Riverside, because as I recall, we suggested that it did not control the definition of waters, or certainly did not have an overwhelming impact on the definition of waters.
Thank you, Justice Thomas. Yes, in terms of the case law, no decision of this court has ever relied upon 404G to affirm the version of adjacency that the EPA and the Corps advance. The most was Riverside Bayview, which said that 404G simply means that some wetlands will be regulated, but the court was not willing to go much beyond that. And with respect to how adjacent actually appears in 404G, given the context of physical topographic features, I think the most plausible understanding of that term is that Congress simply meant that those wetlands that are physically touching, the very facts that were at issue in Riverside Bayview, the fact that Riverside Bayview's property was essentially a cattail marsh that blended into Lake St. Clair. And I think that is the most that 404G says. And again, that's a proposition that the Sackett's test is fully consistent with. The Sackett's acknowledge that some wetlands can be regulated under the line drawing problem standard. It's just that nothing in 404G can reasonably be interpreted to represent some general congressional ratification of the Corps' adjacency regulation from 1977.
Thank you.
Justice Alito?
Well, this case may have an important nationwide effect, but we do decide concrete cases and controversies. So I would like you to address the theory that the government uses to determine that the Sackett's property constitutes wetlands that can be regulated. The property, as I understand it, is separated from wetlands by a road. Isn't that right?
Yes, Justice Alito, by a road, and then a roadside ditch on the other side of the road. That ditch then spills about a half-mile downstream into Kalispell Creek, which then itself spills another 1,000 feet from that point into Priest Lake.
And how does the water from the Sackett's property get to the ditch?
The short answer, Justice Alito, is that the water doesn't get to the ditch. It doesn't get to the wetlands. It doesn't get to Priest Lake. There is no surface connection from the Sackett's property to any plausible water.
What is the government's theory of how the water from the Sackett's property gets to the wetlands?
The government doesn't have a theory for that, which I think underscores how broad the significant nexus test is. The government's theory is that the wetlands on the other side of the road, which are not connected to the Sackett's property, that those can be combined with the Sackett's property on some theory that they're similarly situated, and only because the government then combined this 36 acres of wetlands that it could then conclude that there was a significant relationship to Priest Lake.
So it's only by combining the water from the Sackett's property with this large wetlands that it comes to the conclusion that there's a significant ecological effect on Priest Lake?
Yes, Justice Alito.
Priest Lake is navigable?
Yes.
Does it cross a state line?
No, it does not cross a state line.
If someone puts a boat in Priest Lake, is it possible to get to another state from Priest Lake?
One would probably have to negotiate some rapids through Priest River. But I think it's fair to say that Priest Lake would certainly qualify as a water of the United States according to the interpretation that the Sackett's have offered.
Thank you.
Justice Sotomayor?
Yes. Counsel, I think that there has been a misreading, and I obviously could be doing it, but I have read Justice Kennedy's significant nexus test. And as I read his decision, he was of the view that adjacency defined wetlands that were adjacent to navigable waters, and that he was applying the significant nexus test to deal with non-navigable waters that might be waters of the United States. And so I think that there are two issues in this case. Justice Alito referenced only one of them, which is whether or not the tributary that runs from the Bay Fen to the Sackett site, whether that is a marshland that constitutes a water of the United States. That's what the Ninth Circuit saw. But there is also the Sackett site running directly to Priest Lake. And that Sackett site does run across below a road and below some houses. I believe the government's position, and it could speak for itself when it gets up, is that that connection is very direct, that there is a subsurface flow, not a groundwater flow, but a subsurface flow of water. Isn't that, am I correct about the factual nature of this case?
Justice Sotomayor, you're correct that the record contains some evidence to the effect that there is a subsurface flow from the fen wetlands that are north of the site, south underneath the Sackett's property.
I'm not going that far. I'm going from the Sackett site to Priest Lake. There's some evidence there's a subsurface flow there.
That is correct.
Now, as I understand it, there's a difference between groundwater and subsurface flows. Am I correct about that, too?
I don't believe, Justice Sotomayor, that EPA has ever made such a distinction. And certainly in the position of someone like the Sacketts, there practically is no distinction, whether it's subsurface or really subsurface.
Well, I think
it's
not that hard. I mean, yes, you can see it. And you can see subsurface water when you put your foot in the sand and you can feel it underneath the top of the sand. You could feel it in how watery your soil is. I mean, it's not impossible to know that there's a subsurface. You could put a stake or a plot or something into it and feel it immediately or have it spring up immediately. So there is a difference between groundwater and subsurface water, isn't there?
Justice Sotomayor, I don't believe legally there really is any distinction. Again, if the relevant point is, can one distinguish anything on the Sackett's property from Priest Lake, whether it's subsurface or substantial?
But you don't think there's a difference?
Well, one thing, Justice Sotomayor, that I think is problematic with relying upon any sort of subsurface connection is that it essentially renders the test limitless. I mean, it's hard to imagine.
Why?
It's hard to imagine any property in this country that does not have some degree of subsurface flow at whatever depth that will ultimately, I mean, the hydrological cycle is unified. Ultimately, that water is going to flow to some surface water. It's hard to imagine that Congress could have intended, especially in a statute that imposes such significant penalties for someone who guesses wrong as to whether or not his or her property is regulated.
Well, that goes back to Justice Jackson's point that what Congress was concerned about was ensuring the sanctity of our waters, and that those things that directly discharged into it would be safe, to keep our water safe.
Well, Justice Sotomayor, I also think Congress was concerned about the sanctity of freedom and private property rights and ensuring that people at least have fair notice as to whether their property is going to be regulated. If the test is surface to subsurface.
Why is it fair, whatever test, even yours right now, as you, in your answers to the Chief Justice, said that we'll have to define what a normal season is. We're going to have to define how many days are continuous. So it's not a question that any test that's being proposed won't have some lack of security for homeowners. The one thing about the EPA process is you could always ask the EPA for an opinion as to whether or not you fall within the definition.
Yes, Justice.
And you then have an opportunity to fight that definition, correct?
That is correct, Justice Sotomayor, but I think that actually indicates why something like the significant nexus test is so problematic. It's hard to imagine any other statutory system in the federal code that requires a potentially regulated party to initiate a rather expensive and time-consuming process just to find out whether, in fact, one is regulated. And that's precisely why the jurisdictional determination process has been developed in the age of the significant nexus, because it is a test that's very difficult to know whether, in fact, one is regulated.
Well, that test applies, as I mentioned, only to connections that are not directly with waters. That's a different issue, but that's not how that's not how you brief this case or what we're looking for. We're looking for a definition that has to do with a connection that exists with traditional navigable waters. We may have to develop, as was the insight of Justice Kennedy in Rapanos, a different test like the significant nexus test for those connections like here where there might be a tributary somewhere else.
Justice Sotomayor, I would say that if the test is subsurface connections to a traditional navigable water, I guarantee you that this case or something like it will be back here in another 16 years, and we will be back in the same place that we have been, with property owners not knowing whether they're regulated, with the states not knowing what test to apply.
That's assuming it's subsurface water is not differentiated between groundwater.
Justice Sotomayor, again, I don't think that there is certainly a legal distinction that EPA has ever articulated between the two. And moreover, I think as a practical matter to the property owner, if it's subsurface, it doesn't necessarily follow that one standing in a marsh. The Sackett's property certainly wasn't a marsh. And there's no reason that...
Only because they put gravel in it.
I'm sorry?
Only because they put gravel in it.
Well, the original state of the property was before the topsoil was taken out and the gravel was put on it. It looked like a buildable lot. In fact, it was zoned as a buildable lot. It has a sewer hookup. It has an address. Neighbors around that property have built. There's no sense that this property is something that one might think, there's water somehow flowing underneath it that connects it to Priest Lake. That's not the type of topography.
Thank you, counsel. Justice Kagan?
Mr. Schiff, do you think there's any third position? I mean, I understand that you don't like the significant nexus test, but I'm going back really to Justice Kavanaugh's point about, take something like you just create a dam so that, and the dam breaks up any idea that there's a continuous surface connection. So if I think, well, in that kind of situation, it just can't, you can't be right, but I also understand some of your points about the significant nexus test. Is there anything in the middle?
To some extent, Justice Kagan, I think a middle position is the idea of the nature of the barrier. I think this came up a little bit, whether it's a natural barrier or whether it's a permanent legal barrier like the roads that bound the Sackett's property. But in a sense, it's not a particularly satisfactory middle position, because it still doesn't really afford appropriate fidelity to the text. Again, if Congress could tomorrow enact a statute.
Well, I think I'm asking you to assume that 1344 means more than you think it means, and suggests that there is something in the text that says we're supposed to figure out what it means for an adjacent wetland, for a wetland to be adjacent. So if I'm thinking of Justice Kavanaugh's example and thinking that looks pretty adjacent to me, but on the other hand, I'm thinking of some of the objections that you have as to the Kennedy test. What do I do from there? Is call it a backup position, call it a compromise position, call it whatever you want. Is there a third option?
In that sense, Justice Kagan, I think there is. I mean, it's exemplified by the facts of the Sackett's case, in that there's not even there's no surface connection, much less there's no surface connection from the Sackett's property to any plausible water. I mean, I think certainly...
That's just repeating your test. I'm asking you for a test that's different from your test.
Well, I would hesitate a little bit to say it's the same thing, because our test is the line drawing problem test. But one could say that whether there might be marginal challenges about defining boundaries in other cases, certainly where there's no surface connection, there cannot be any plausible argument that the wetland itself is inseparably bound up with an abutting water.
So your answer is no. Okay, thank you.
Justice Gorsuch.
I'd like to return to where Justice Sotomayor left off, and that is adjacency. If we're going to have something more than a continuous water surface test like we did in Riverside Bayview, if we're going to expand beyond that, why not just look at the geographic proximity between this property and the lake? The lake is the waters of the United States that EPA wishes to protect, understandably. They've got a circuitous route across a road, down a drainage ditch to an unnamed tributary to a named tributary to the lake. That's their adjacency theory. It's kind of a daisy wheel spun out from the lake. But that's rather complicated when one looks at the map. I mean, and it's the back of the petition appendix, the picture. You're blocked from the lake. Why isn't that just adjacent enough? Now, there's a subdivision between you and the lake, I understand, but pretty close. A lot closer route that way than this rather convoluted path around.
Justice Gorsuch, I think the reason why that's not satisfactory, and I recognize that I've given this answer in more than one form several times already this morning, but I would still go back again to the text. It was obviously Congress knows about wetlands. It included a reference to wetlands in 404G, among other places. It chose not to include that in the definitional section. That has to mean something. And what that means is that the relevant jurisdictional entity is water. If something cannot be reasonably classified as a water, taking into account the line drawing problem standard, then the answer is simply Congress hasn't authorized it. Maybe it is a good idea in terms of water quality, but that's for Congress to decide, obviously, not for the court. And that really has to be why mere geographic closeness can't justify the contratextual conclusion that a 2/3 of an acre residential lot with a sewer hookup, with an address and a mailbox, is somehow considered the water of the United States.
And that is what's being asked, is a person who purchased a property with a sewer hookup, a block from a lake with a subdivision between you and the lake and a road on the other side, is supposed to know that that's a water of the United States, that piece of property, or else what? What are the penalties associated with this? What was threatened to your clients, and what does one face in these circumstances?
Well, certainly for the Sacketts in particular, they were threatened with significant civil and administrative penalties, and of course also the continuing liability of having to restore the property to the way it was before they began any work. But also there is lingering over all of this discussion the threat of criminal penalties. And I think this is particularly important because the waters of the United States is as much relevant to the criminal portions of the Clean Water Act as the civil portions. It's the same text. And I think that should give the court particular concern in indulging any sort of malleable or somewhat unclear or flexible test exemplified by the significant nexus test.
Thank you. Justice Kavanaugh?
You keep emphasizing the text, but you agree that some wetlands are covered as waters of the United States, correct?
That is correct, Justice Kavanaugh.
And so the question then becomes, as I see it, does the statute, does the text cover only bordering or contiguous wetlands, or does it also cover what we might call neighboring wetlands? Is that an appropriate way to phrase what you think the precise dispute is?
Yes, that is correct.
Okay, and on 404G, which, as Justice Barrett says, is critical here to the case, is your argument that 404G does not control or even illustrate what qualifies as waters of the United States, or is your argument that adjacent, the word in 404G, does not mean neighboring or nearby, but requires actual touching?
Justice Kavanaugh?
Or both?
I would say it's both. I would say, again, following precisely what Riverside Bay, which is essentially the zenith of this court's indulgence of EPA and the Corps' interpretation of the Act. At most, Riverside Bayview was willing to say that 404G simply means that, well, we can't interpret waters to categorically exclude wetlands. And that's all that the court was willing to say.
Once you get there, aren't you a little bit separated from the text as you see the text? In other words, I don't know that you really agree with Riverside Bayview when it comes down to it. You're not asking for it to be overruled.
Well, Justice Kavanaugh, to be frank, we weren't all textualists then. But today... So,
but then you're asking us to put what you're calling a textual limit on something that's divorced from the text to begin with. It sounds to me like, rather than going with neighboring, which is the ordinary dictionary definition of adjacent, and also would I'll leave it there.
Well, Justice Kavanaugh, with respect to the ordinary understanding of adjacency, I certainly agree that in the abstract, adjacent has more than one meaning. But I do believe that in the context of 404G, where it's trying to describe relationships between topographic features, that the most reasonable understanding, really the only plausible understanding, is that it means physically touching. Again, when you combine it with the fact that the central definitional section...
Last question. Why did 7 straight administrations not agree with you?
Well, I wouldn't quite say it's 7 straight. At least under the Trump administration, their proposal was certainly closer to what the second...
No, let's be clear. They said that it would still be covered even if it was separated by a berm or dune, for example.
No, that is correct.
And under your test, that would not be covered.
That is correct, Justice Kavanaugh, and I don't presume to know more than those 7 prior administrations. But what I do know is what is the text that Congress has used, and nothing can supersede that.
Thank you.
Justice Barrett?
Mr. Schiff, can you explain to me why you wouldn't lose? Because I take it you're saying that you wouldn't lose if we had dropped a broader definition of adjacent, akin to the one that Justice Kagan is proposing.
Justice Barrett, I may have misspoken. If adjacent means that something is not adjacent if there is a man-made barrier as opposed to a natural barrier, then obviously here the Sackett's property is bounded by man-made barriers. And so what I meant to say is that whether or not, if the court thought that natural barriers might not defeat jurisdiction, the court could also say that at least here, with man-made barriers, there is no jurisdiction.
Okay, I think I didn't articulate my question clearly enough.
Sorry.
So part of what you've said is that 1344G, Congress was doing something different, and that it didn't modify the definition of waters of the United States that was existing. Okay, so here's my question. It seems to me, and this was kind of what Justice Jackson was getting at, that might be true, that 1344G was doing something different, but what it was doing was carving out what the states could and could not regulate. And if adjacent means something broader, and this is what I was starting to ask you when the time expired, if adjacent means something broader, then it seems to me that there's a category of wetlands that nobody could regulate. So it seems to me that even though 1344G was doing something different, and even though Congress didn't modify the definition of waters of the United States, that adjacent matters to this case. And if we adopt the definition Justice Kagan is proposing, that you would lose. Am I right?
Justice Barrett, if I understand what Justice Kagan is proposing, that neighboringness or mere closeness is sufficient, then necessarily, the Sackett's property and a lot of other property in this country is going to be regulated. So
in that respect, 1344G does qualify or cast light on the definition in 1362(7) of waters of the United States.
It certainly does, and as I responded to Justice Kavanaugh, the way it casts light is to indicate that, to some extent, wetlands are going to be regulated. The extent to which they're regulated, I think that has to be, in a sense, a tail wagging the dog problem.
But that depends on our accepting the narrower definition of adjacent, correct? I mean, I see why your whole theory hangs together if adjacent means abutting.
Right, Your Honor, and what I mean by tail wagging the dog is that I don't think it's really appropriate to look at how adjacent is used in 404G and then use that to sort of reinvent what the central definitional section from Section 502 is. Rather, it's the other way around. It's precisely because Section 502 was not changed that the criterion remains waters, that must then inform what adjacent means in Section 404.
And is the idea partly that because 1344G was enacted in 1977 and 1367 or 1362(7) was that 1972?
Yes, that's correct.
But in any event, it was preceding that the later legislation doesn't cast light on what the original meaning of waters of the United States was?
Well, it's certainly not definitive. It's not a ratification. And I don't want to go too far, Justice Barrett, in saying that it means nothing, because, again, Riverside Bayview says it does mean something. But, again, it would be strange, it would be a sort of an inversion of statutory interpretation to say that this parenthetical reference in a provision dealing principally with permit transfer authority suddenly backfills and dramatically changes the scope of the central definitional portion of the Act. Again, a portion that is as much at issue in criminal prosecution as it is in civil matters.
Thank you.
Justice Jackson?
Sorry. So you said several times that Riverside Bayview said at most that some wetlands could be regulated. But under your test, it appears that you are requiring visual indistinguishability. And I'm trying to assess whether or not Riverside Bayview actually gets you there. In that case, was it clear that the marsh area was visually indistinguishable from the abutting creek?
Yes, Justice Jackson, that is precisely how the government argued it in its briefing and at oral argument. We quote that portion in our reply brief, where the emphasis is on how, I believe these are the words that were used, that from Riverside's Bayview, it would not be an exaggeration to say that one, after wading through a cattail marsh, could then swim into Lake St. Clair, that it was a continuous body of water that at some point ended. And the court, in looking at those facts, said that it's appropriate to defer to the Corps and the EPA in saying that the water ends at this point because we can't otherwise say whether it's reasonable to have it end at an earlier point.
But do you think that is that going to be the case in every situation, that it's indistinguishable as to when the marsh ends or the wetlands end and the creek begins? I'm just trying to imagine whether people were really confused in Riverside Bayside as to which part was wetland and which part was water, and is that your test? We have to have a visual indistinguishability.
Justice Jackson, there was certainly a dispute among the parties as to the proper characterization of the facts. But I think what matters are two things. One is how the government presented those facts to the court and how the court ultimately crafted a decision based upon those facts, meaning that the court concluded that, as it said, between dry land and open water, the transition is not necessarily or even typically an abrupt one, and that you have all sorts of features in between those 2 points. And the court said that it's not our place to second-guess the agency's determination that in drawing the boundaries of waters, which is the central jurisdictional term, in drawing the boundaries of waters, it's not unreasonable that there may be some semi-aquatic features that are brought into that boundary.
So under your test in future cases, are we going to be debating in every case the extent to which there really is visual indistinguishability?
Absolutely not, Your Honor, and I think that if there were disputes, those disputes would pale in comparison to the number of disputes that have percolated throughout the lower courts over the last 16 years with respect to the significant nexus test. This test, the line drawing problem test, is much simpler to apply.
Thank you.
Thank you, counsel. Mr. Fletcher.
Thank you, Mr. Chief Justice, and may it please the court. As the discussion so far illustrates, everyone agrees that the waters protected by the Clean Water Act include some adjacent wetlands. The narrow but important question presented in this case is whether wetlands lose protection if they're separated from other waters by a barrier like a berm or a road. Overwhelming scientific evidence and essentially undisputed scientific evidence shows that those sorts of barriers do not diminish wetlands' essential role in protecting the integrity of other waters. And as Justice Kavanaugh emphasized, for 45 years, the EPA and the Army Corps have recognized that the presence of such a barrier does not categorically strip a wetland of the Act's protections. This court should uphold that long-standing interpretation for 3 reasons. First, in 1977, Congress was presented with proposals to limit the Act's coverage that sounded very much like the proposal that you just heard, and it rejected them. Instead, it adopted Section 1344G, which includes express textual recognition that the waters covered by the Act include adjacent wetlands. The court recognized in Swank, in the language that Justice Sotomayor quoted, that that was an unequivocal approval of the Corps' regulation on adjacent wetlands. Second, this court unanimously upheld those regulations in Riverside Bayview. Now, it's true that the marsh at issue in that case happened to directly abut a creek such that one could wade from one and then swim in the other. But the court did not rely on any difficulty in identifying the boundary between the creek and the lake, and there wasn't one. Instead, the court relied on what it called the agency's ecological judgment that wetlands significantly affect neighboring waters. And the presence of a berm or other barrier does not sever that connection. In fact, as the 2020 Navigable Waters Protection Act emphasized, the presence of a river berm can itself be evidence of the close connection between the river and the neighboring wetlands. Third, and finally, the agencies are now doing what members of this court have repeatedly urged them to do by promulgating regulations that recognize and appropriately limit the coverage of the Act. Those regulations incorporate the significant nexus test, which is a limiting construction that ensures that the Act reaches only those wetlands that must be covered to reach the traditional navigable waters in which the federal interest is indisputable. I welcome the Court's questions.
Is, under the position of the federal government, is a ecological and biological connection between wetlands and navigable waters enough to bring the wetlands into coverage? In other words, dry land between it, but underneath, we had that case in Hawaii that indicated how far underneath it could go. There is a biological connection. You put some tracing materials in the wetlands and they do find their way to the lake. Is that enough under your view?
Not any connection. We're not talking about the possibility that some molecules of water eventually make their way from the wetlands into the lake, but instead what we take to be the significant nexus standard from Justice Kennedy's opinion in Rapanos, which traces back to Swank and Riverside Bayview, that demands a significant effect.
So what does that mean? I mean, how much of a biological connection does there have to be?
So the agencies now have more than a decade of experience applying this in practice, and they explained in the guidance that they issued after Rapanos and have sort of reiterated and refined in the NPRM that they just issued in December of 2021 the factors that they consider in assessing significant nexus, and it includes things like distance to the tributary, distance to the downstream traditional navigable water, the volume of the flow, the hydrology of the area, the presence of other wetlands. I acknowledge it.
So if the Sacketts or anybody else are walking around the area, they could look at something and see how long, what's the distance factor?
So the distance factor isn't a bright line rule.
Okay, so they know it's not a bright line rule, but they have to figure out if a certain amount of whatever kind of tracing thing you use is deposited in the wetlands. They then have to figure out if that makes it all the way to the lake, no matter how far away it is. And I think, as your friend pointed out, I forget what the phrasing was, but water goes everywhere eventually, right? And so there's probably going to be a biological or ecological connection of some sort.
So I'd say a couple things. First of all, this case is focused on provisions addressing adjacent wetlands. There are other provisions of the regulation dealing with isolated waters that aren't at issue here, but for purposes of this case, there has to be a showing of adjacency. And right now, the Corps and the EPA have not tried to reduce that to a bright line rule. They tried that approach in the 2015 rule, and that was criticized by many as being arbitrary.
Have they tried to reduce it to a vague rule?
Yeah, I think they've said reasonable proximity, and they've said that reasonable proximity depends on the hydrology of the area. If you have a flat floodplain where often floods from the river reach waters or wetlands that are at some distance
so
from
somebody
the river,
looking around a lot would have to look at the wetlands if they can see them and the lake and say, is that reasonable proximity or not?
That's right. Yes, that is the standard. And
that's a standard that is used in criminal prosecutions as well.
That's correct, Mr. Chief Justice, but I don't think that's an unusual standard in regulatory or criminal statutes. And as the most recent example, I'd point to the court's last Clean Water Act case, County of Maui, where the court adopted a standard for indirect discharges into the navigable waters. And the dissents criticized that standard because it was a multi-factor test that was not capable of being reduced to precise rules.
Yeah, but the sewage plant was pretty proximate to the ocean, right? How far apart away was it?
I don't remember exactly how far apart, but it was pretty proximate. But on the other hand, the Sacketts wetland is pretty proximate to the tributary and the lake. We're talking about 30 feet to the tributary and just 300 feet to the lake itself.
Well, yeah, in the Hawaii case, though, we were talking about a big sewage plant.
So that's right, Mr. Chief Justice. And I guess I think this gets to another issue in the case, which is that what we're talking about now is whether wetlands are brought within the Act's coverage at all. The fact that they're covered by the Act does not mean that development is prohibited. It just means that development has to be permitted. And if the Sacketts wetlands would not significantly affect or degrade Priest Lake because of their location or their size or anything else, that's something that's appropriately taken into account in the permitting process. This is just about which wetlands are going to have some examination to make sure that that degradation does not occur.
Clarify some of the answers that you just gave to the Chief Justice. I mean, the statutory language is of adjacency. And at certain points in your answer, you suggested that the significant effects test is really just the test that you use to evaluate whether there is sufficient adjacency. At another point, when you talked to the Chief Justice, you said that the test was reasonable proximity. Is reasonable proximity the same as significant nexus? Is what you're doing trying to figure out how, other than by demanding strict contiguity, one defines adjacency? And then, dealing with the hard issue of it just doesn't seem as though it should be 50 but not 51. But I think what the Chief Justice is asking you is, well, what do you look to then? Name the three things that matter when you're saying, is something adjacent enough?
Right. So significant nexus and adjacency are separate concepts. Adjacency traces back to the original regulations from 1975 and 1977, picked up in Section 1344G. The agencies have long said that adjacent wetlands are covered. In Rapanos, Justice Kennedy's concurrence said that for traditional navigable waters, he accepted that adjacency alone was sufficient to justify inclusion. But for wetlands that were adjacent to tributaries further upstream, Justice Kennedy thought that some additional showing had to be made.
If you're going to separate them, which I had thought that you hadn't done, so my mistake, but if you're going to separate them, where does the significant nexus test come from?
So I think it's a limiting construction that limits the broad language of the statute is waters of the United States, and as I think the court has recognized, that could conceivably cover literally every body of water in the country. We know it doesn't mean that. We also know it means something more than just navigable waters, and so we need a test to figure out which additional waters are covered. And what the significant nexus test does is it says it's permissible to sweep in additional waters if they significantly affect the traditional navigable waters that were the sort of core focus of the Act.
Well, you haven't told me where that comes from. I mean, it sounds like a very good idea to have such a test, but where does it come from?
From this court's cases, which say you have to give effect to two things. The term being defined is navigable waters, but the definition is broad and doesn't include any requirement of navigability. And the way we read Riverside, Bayview, and Swank is to say you can include other waters that are not themselves navigable, but the justification for including them has to be their effects on the traditional navigable waters that are the core of the statute. Things like migratory birds, that was the issue in Swank, aren't good enough.
And they need not be adjacent. So what Justice Kagan's questions is getting to, and I want to make certain I understand it because it's important to me, the significant nexus test is separate and apart, so it can be not adjacent, but so long as there's a significant nexus, it's still covered. It's untethered from 1344G in that respect.
I want to be very clear to distinguish between what we think is you have to decide in this case, and then also in candor tell you what the agency's view is about other circumstances. So this case is about the regulations dealing with adjacent wetlands, and as to those wetlands, the agencies think they're covered if they're adjacent to traditional navigable waters, or if they're adjacent to upstream tributaries and they satisfy the significant nexus test. It's an additional limiting construction that narrows the scope of the Act.
I'm sorry.
I was just going to say the agencies have also said, and this is reflected in the notice of proposed rulemaking, they would cover other waters, even if they weren't adjacent to navigable waters, if they could satisfy the significant nexus test. But that's not really before you here, because everyone agrees that if you accept our view that adjacent means neighboring, then the Sackett's wetlands are covered. I'm sorry, Justice Alito.
What is your understanding of the term waters?
We think so our understanding of it is reflected in the agency's regulations, which have for 45 years spelled out the different sorts of waters that are covered. I think if I were going to reduce it to a phrase, it would be geographic features that are characterized by the presence of waters. And I think where I'd part ways with my friend is that I'd say that's not just lakes, streams, and rivers, it's also marshes and swamps.
Any geographic feature that has water in it, at least at some period during the course of the year, that falls within the term waters?
So again, as I said, this is something that the agencies have fleshed out over many decades, and one of the things that they've done is exclude, both because of particular statutory provisions excluding particular types of waters, and also because the agencies, as a matter of regulation, have excluded things like irrigation ditches, waste treatment systems, small erosional features, those sorts of things. So I don't want to say...
They can be man-made features, right?
That's correct, yes.
Why aren't irrigation ditches included?
I think irrigation ditches aren't included both because the agencies have made the determination that it doesn't make sense to include them, and also because typically irrigation ditches bring water from the waters of the navigable waters, canals, rivers, things like that, and distribute it out into rivers. They're not bringing water back into the navigable waters.
Well, if we forget about everything the agencies have done and everything this court has said about the question of what constitutes waters, what would you say is the definition of waters? Is it a definition was provided by the plurality opinion in Rapanos? You disagree with that. Does it include any place in the United States that has water in it?
No, I don't think it does. I accept the Rapanos plurality's idea that it is of geographic features characterized by the presence of water. I go further than that and say that wetlands can easily fit that description. And I acknowledge that there are some difficult cases about how do you distinguish between a wash and an intermittent or a seasonal stream or a river. Those cases really aren't before you here. This is a case about whether adjacent wetlands are waters. And I think on that point, the sort of clearest place to look is Section 1344G.
No, but we need to know what waters of the United States means. That's what we're interpreting. We're really not interpreting 1344G. 1344G may shed some light on what is meant by waters of the United States, but we're interpreting what is meant by that phrase, that cryptic phrase, strange phrase, waters of the United States.
So I agree exactly with the description of what the court ought to do. And my point was just that it's a difficult problem of how to interpret it and apply it to all of the different water features in the country. And I was trying to emphasize that the specific question before you is what to do about wetlands adjacent to other waters. And on that point, 1344G's text and history, I think, speak very clearly and provide, in our view, dispositive guidance about how to interpret and apply that general statutory language.
But the text doesn't say, in referring to adjacent in 1344G, whether that means bordering or contiguous, and stop there, or also include neighboring as the regulation does. And as I understand the case, really, as your brief set it out, comes down to, okay, what about a wetland separated by a berm or dune or by a dike or levee? And on that question, I suppose, since Congress hasn't specified that it goes that extra step, why not let Congress figure out where the line is? I mean, I think that's the toughest hurdle you face, is that Congress, we've gotten, as Justice Alito says, from waters to adjacent, and now from contiguous or neighboring to contiguous or bordering to also neighboring, and shouldn't that be Congress's job? So what's your general response to that?
So I think if you look at 1344G in context, Congress has answered this question. We think you'd get there past just directly abutting and to neighboring on the dictionary definitions alone, the definitions we cite at page 22 of our brief. But I don't think you need those here because of the history against which Congress acted. And Justice Barrett, this goes to your question about the chronology. The Corps of Engineers first defined the waters of the United States to include adjacent wetlands in 1975, in interim regulations issued in 1975. And those regulations said adjacent or contiguous to. And so I think already made clear that we're not just limiting to contiguous regulations.
Then it spelled it out only in 77.
Then in July of 1977, it spelled it out. It said we're deleting contiguous because that's a subset of adjacency, and we're making explicit that the presence of a barrier like a berm or a dune is not enough to defeat adjacency. And then Congress comes along in December of 1977, and in this carve-out in 1344G, which is dividing up which waters are going to be covered by the states, which are going to be reserved to the federal governments. And in doing that, Congress drew a line that was reflected in the Corps' regulations. The Corps had, when it expanded jurisdiction out, it said we're going to phase in this expansion of our jurisdiction, and we're going to start with traditional navigable waters and their adjacent wetlands, and then we're going to move to other things later. And what Congress did in 1344G was say the federal government is going to keep permitting authority over phase one, and the states can take permitting authority over everything else. And I think that context makes it especially clear that Congress was picking up the concept of adjacency that was reflected in the Corps' regulations.
But it's kind of a bank shot way to do it. You would acknowledge that.
So I guess, Justice Kavanaugh, I think...
And you use the phrase shed light on. What does that mean?
Well, I think confirm that the agency's understanding was correct. So, this is the term waters of the United States. The Corps, the EPA, the Department of Justice, the courts all interpreted that to reach adjacent wetlands. And Congress was then presented with a lot of the same objections you're hearing now, with people saying this is too much of an intrusion on the states, this is messing with farming and ranching and other activities. And there was a serious proposal to curtail the jurisdiction in the way that they suggest.
And Congress carved out farming and agricultural activities.
Exactly right. It did something different. It said we're not going to accept the proposal to carve out wetlands from the Act's coverage entirely. Instead, we're going to do three things, actually. We're going to carve out certain activities like farming and ranching. We're going to transfer permitting authority over some wetlands to the states to give the states a greater role in things. And then we're going to ratify this concept of general permits to streamline the permitting process. So it was sensitive to these concerns, but it rejected the idea of carving off wetland coverage in the way that petitioners are now.
If 1344...
I'm sorry. Justice Gorsuch.
Mr. Fletcher, I just want to understand your concept of adjacency and how it differentiates from substantial nexus. So your first point was that if it's adjacent to a water of the United States, we're done. We don't do the substantial nexus test. And I want to understand how much adjacency is adjacent. And I think you indicated that you thought that this property, and I just want to make sure I heard you right, that this property is adjacent indeed to the water of the United States because it's close enough to Priest Lake itself.
So that is my view. I want to be clear about how the case has developed, though.
I just want to make sure, I just want to understand that's the view of the government. Despite the fact that there's a subdivision between this property and the lake, it's still adjacent to the lake.
That's the government's view.
And it's adjacent, why? What's the definition of adjacency that's independent from substantial nexus? And then I have a couple follow-ups to that.
Sure. So it's the agency's understanding of adjacency is, neighboring, and they have cashed that out by saying it's a reasonable proximity to a covered water.
Is there a mileage limit to that?
So they haven't tried to do that. They did try that in the 2015 rule. They said they are anything within 100 feet or anything within the 100-year floodplain and 1,500 feet.
But those have been rejected.
Those have been rejected.
So does a reasonable landowner have any idea? So, for example, in Priest Lake, I imagine that most of the water flow and rainfall and snowfall in quite a large geographic area drains into the lake eventually, or wishes to unless diverted. Would that whole watershed be adjacent to?
So I don't think so, Justice Gorsuch, and also as I am sympathetic to the idea of how does a landowner know under the standard whether their land is covered. It's important to recognize that there are other limits too, where they have to actually be wetlands. So
no, I understand that. I'm just asking about adjacency.
Understood.
How does anyone know, any reasonable person know, within maybe several hundred square miles in a watershed that drains into a body of water that is the water of the United States, know whether or not their land is adjacent to?
So I think we are talking about adjacency, and that may not be something that gives you bright line rules, but it rules out things that are many miles away.
Does it? Are you sure the EPA would take that view?
I've asked this question. The agencies have told me they do not draw bright line rules. They do not think 300 feet is unreasonable for adjacency.
So how about 3,000 feet? Could be?
I don't know the answer to that, Justice Gorsuch.
Could it be 3 miles?
I don't think it could be 3 miles.
Is there a process
I'm sorry. So it couldn't be 3 miles?
I don't think it could, Justice.
Could it be 2 miles?
That, again, when we start to talk about miles, that sounds too far to be
1 mile?
Approximate to me. Again, and I see where this is headed, but again, I just want to know.
So if the federal government doesn't know, how is a person subject to criminal time in federal prison supposed to know?
So the agencies, in recognition of this problem, make available free of charge jurisdictional determinations as to any property. They also publicize their manuals and make available on websites every jurisdiction.
They're manuals that don't tell us the answer.
So I understand, Justice Gorsuch, and I think you could make similar criticisms, and dissenting justices did make similar criticisms of the functional equivalent to an indirect discharge standard in County of Maui. And the court recognized that sometimes Congress gives us laws where the text isn't susceptible of bright line rules. I think adjacency is one of those bits.
I'm done on adjacency. I got some substantial nexus questions, but I got a colleague who wants to ask a question.
Yes, I just wanted to follow up on Justice Gorsuch's very fair points, which were my points. How do people know? Is there a process by which a homeowner can ask?
Yes. Any homeowner can ask the Corps for a jurisdictional determination. The Corps makes those available free of charge.
And so you're not really facing criminal liability without the opportunity to get an assessment from the government regarding your particular circumstances.
That's correct.
All right.
And what happens if if the government's determination based on this multi-factor test is that you can't develop your property? Then what recourse does the homeowner have?
The homeowner can challenge that determination. If we're talking about a determination that you can't develop, that wouldn't just be a jurisdictional determination. That would have to also be a permitting decision, because just being covered doesn't mean you can't
what
develop.
If the homeowner doesn't agree with the jurisdictional decision?
This court's decision in Hawks makes clear that the homeowner can seek judicial review of that at that point without potentially incurring any penalties, can challenge the jurisdictional determination there, and can also seek a permit. And that is, I think it's important to emphasize just again that being covered by the Clean Water Act doesn't mean no development. It means review, and the Corps have taken a lot of steps at the Congress's behest to streamline the process through the availability of nationwide permits for things like road construction, for the development of dams, for single-family home construction.
But the site-specific, which is applicable to the SACITs, you don't dispute in your brief that that can cost hundreds of thousands of dollars and be years and years. It's just the general permitting that gets you out of that and gets you in the $14,000 range in the shorter time period.
So we think the several $100,000 is exaggerated for the site-specific permits as well. The same source that we cite on page 37 of our brief for the $4,000 to $14,000 for nationwide permits gives numbers of $17,000 to $35,000 as the usual cost for site-specific. That's right. And it's also important to recognize that those site-specific permits often involve much bigger projects that could be major developments spanning many, many acres. So that's the agency's best estimate of the cost of a typical.
So Rapanos was just wrong in citing that statistic.
In our view, that statistic is not consistent with the best information we have now, and that's from the 2021 regulatory impact analysis of the reissuance of the nationwide permits.
Your adversary, the other side, I shouldn't call him adversary, the other side, argued that Mr. Sackett could not tell this was a marshland. Is that true? Because you said the first thing is it has to be a wetland.
So I don't know what Mr. Sackett could tell, and I don't want to speak to that. What I can speak to is what's in the record, which is communications from the Army Corps to the prior owner in 1996 saying this is a jurisdictional wetland, you would need a permit to build, here's information about how to seek nationwide permits. And we also have the pictures of the property that are at Petition Appendix 37 to 39 and also in the Joint Appendix. Now, we don't have pictures before it was filled in with gravel, but the pictures after it was filled in with gravel show that the parts that are not filled with gravel have standing water in them. And also the Sackett's own environmental consultant who came and looked at the property confirmed the Corps' judgment that these are wetlands. I think it's also worth emphasizing that although they're now separated by the larger fen across the street by Kalispell Bay Road, historically, before the road was built, that wasn't true. It was all part of one wetlands complex, and the whole fen drained down through the Sackett's property and into Priest Lake.
Is it possible? Go ahead.
Just one last question, and borrowing from what Justice Kagan did before. As you can probably tell, some of my colleagues are dubious that this is precise enough definition, adjacency, to survive. So is there another test, not the Rapanos test, not the adjacency test, not the significant nexus test, but is there another test that could be more precise and less open-ended than the adjacency test or the significant nexus tests that you use? Is there some sort of connection that could be articulated?
So I'd say a couple things about that. I'd say, first of all, that if you're in that world, you're past the sort of line drawing problem or the notion that wetlands aren't really waters and so are only covered if they're indistinguishable. And instead, we're making a judgment about which wetlands are appropriate to cover because of their effect. Now, there are different ways to draw that line. Justice Kennedy articulated the significant nexus test.
But that's when it's not adjacent, correct?
That's when it's not adjacent to a traditional navigable water. That does apply if it's adjacent to a tributary.
Because we seem to be searching for wetlands adjacent, so let's stick to that.
Right. So for wetlands adjacent, if you want a sort of crisper, clearer definition of adjacent, as I think my colloquy with Justice Gorsuch illustrates, I think it's difficult to say that there's one single bright line answer. The agencies are taking comment on this and are considering whether there are things that they could do to provide greater clarity to the regulated public on all parts of the test, including adjacency and significant nexus. The 2015 rule, as we discussed, tried to draw some bright line rules. Those were criticized as arbitrary and over-inclusive, which is the problem with bright line rules. They'll be over-inclusive or under-inclusive. But I certainly think there's a range of reasonable understandings of what adjacency means, and also, I know you're focused on that, but significant nexus
Did I just understand you to say that the rule that you're issuing may in fact have more guidance than we currently have as to what adjacency means?
I don't want to represent what's coming in the forthcoming rule because it's not issued yet, and by definition the agencies haven't finished their deliberation. I will say they've sought comment on how to cash out, how to crystallize this significant nexus test and the adjacency framework that it is a part of. And they've also said that even after this rulemaking, they're interested
When is the rulemaking coming down?
So it's with OMB now. It's public that in September it went over to the Office of Management and Budget for interagency review. The agencies have told me that they still expect to issue it by the end of the year.
Is it possible for you to be correct about the adjacent test as articulated so far, but the Sacketts win?
I don't think so, Justice Kavanaugh. I don't.
Why is that?
So I don't take them to be disputing that if adjacency means something more than just directly abutting or contiguous with, then their property satisfies that standard because it's just 30 feet away from the tributary across the street.
Street, because that's where we need the substantial nexus test, right?
No, the substantial nexus has to go to the navigable water, the sort of downstream navigable water.
I thought if you're adjacent to water of the United States, you're good to go.
I'm sorry, yes.
Okay, but so you need the substantial nexus if you're working through the tributary, which is, if you look at the appendix, that great picture at the end is across the street, through a ditch, and then down through a creek, and then it eventually gets to the water of the United States. And so for that, you need the substantial nexus between the Sackett's property, across the road, and into the ditch, at least, right?
So yes, but with a couple caveats.
Okay.
If I could, you're right that you do need to satisfy the significant nexus test if you're relying on adjacency to a tributary.
Yeah. Okay, so we're going that way. First of all, does the significant nexus have to be to the ditch across the road or all the way down to the lake?
All the way down to the lake. That's the limiting work that it does.
Okay,
it says,
great. That's helpful. How much? It's the same question, different test.
Yeah.
And the chief kind of alluded to this already. How many parts per million of what kind of stuff has to get from the Sackett's property across the road into a ditch? I don't know how many thousands of feet over to a creek, and then from the creek down into the lake.
So I'm going to give you a similar answer, which is to say I can give you qualitative. No. Respectfully, Justice Gorsuch, in law, I think there's a qualitative standard with guideposts that isn't determinative.
You can call out your local friendly agent, and he'll tell you yes or no.
We'll tell you here are the guidelines that the agencies use. They'll tell you free of charge what they think, and if you don't like what they think, you're free to challenge that in court. Yes.
Okay. So we don't know until he comes out and tells you. I mean, what is the standard? I mean, give me your best shot.
So it's, do the wetlands with other similarly situated wetlands significantly affect the chemical, biological, or physical integrity of downstream waters?
And what does that mean?
The agencies look at the functions that are typically performed by wetlands, like retention of floodwaters, filtering of pollutants, provision of flow during dry periods, and they look at the distance. They look at the amount of flow from the wetland and other wetlands down to the downstream navigable water, and they look at the climate.
How is that different than adjacent?
So I think adjacent is focused on reasonable proximity.
I thought that was part of the test you just gave me, too.
Distance is one factor, but what the significant nexus test says is that if you're going to be relying on adjacency to some upstream tributary, that's not good enough to justify coverage. You have to show that that has a significant effect on the downstream navigable waters. It makes it harder to include wetlands that are adjacent only to tributaries and not the navigable waters.
Mr. Fletcher, is the government stopped? Is the Corps or the EPA stopped from going after you if you get a jurisdictional determination and they say, yep, not within our jurisdiction, not wetland, then are you protected?
That's my understanding, at least for 5 years. Jurisdictional determinations are good for 5 years, and I think one of the reasons that this court gave in Hawks for why those are judicially reviewable final agency action is because they're binding on the Corps and the EPA for that 5-year period.
One other question. So the significant nexus test is, you want me to?
Go ahead.
Stop. The significant nexus test, you said, is separate and apart and the subject of a different rulemaking, and that the agency has a broader view than adjacency, that adjacency would be here. So the significant nexus test, I take it, would be grounded in waters of the United States and not 1344G?
That's right, yes.
And if we accepted the significant nexus test, we wouldn't even really need 1344G because it would be broader than adjacency.
I think potentially that's right, but I think that's what makes 1344G makes this case about adjacent wetlands an even easier case and doesn't require you to pass on the validity of that broader theory.
But if waters of the United States already included everything with a significant nexus, then why does adjacency even matter in 1344G?
Well, I think adjacency still matters in 1344G because that's express textual confirmation that Congress understood that adjacent wetlands are coverage. Or the agencies, as reflected in the rulemaking, think that the Act's coverage goes beyond that and in ways that might subsume the adjacent wetlands theory. But I think for purposes of this case, 1344G would still be very, very instructive.
Thank you.
Thank you. Justice Thomas?
Mr. Fletcher, it seems as though when there's a body of water and nearby wetlands, there's a presumption that it's covered by the Clean Water Act. And then the homeowner or whomever owns it or attempts to develop it has to opt out in some way. Can you give me an example of a body of water and nearby land that is automatically or presumptively excluded from coverage?
Sure. So I think if I understand the question, the agencies have defined some automatic exclusions. In addition to just anything that doesn't satisfy the significant nexus test, they've ruled out things like certain ditches that are excavated in uplands, small erosional features, things that are isolated.
No, I mean, I grew up in low country Georgia, and you had standing water. That was normal. And I'm thinking of something that's natural like that is presumptively not covered, and it's not near, not bordering on, I don't want to use the term adjacent, I'm done with that word, bordering on a body of water.
Sure. So I don't know that the agencies have talked in terms of presumptively not covered. I think the best thing that I can point you towards is in the 2021 NPRM, and this is at page 69-432. The agencies, in explaining that the significant nexus test really has teeth, explain that they routinely conclude that waters aren't covered, and they give half a dozen or so specific examples of the types of isolated things that are definitely waters, but still aren't covered because they don't have enough of a connection to the downstream now.
So in other words, if I were still living there, I wouldn't know until you told me.
No, Justice Thomas, respectfully, I disagree with that. I think that if you have an isolated body of water, an isolated farm pond or something like that, there are some things that are categorically excluded. If you're not in one of those categories, the question that you'd have to ask is this adjacent to, or is there a significant nexus with the navigable waters? And I think for an isolated body of water, the answer to that would be no.
And could you, if I were concerned about the authority of EPA to regulate a purely intrastate body of water or associated wetland, where would I find the authority for that? Or would you give me your best argument for the authority of the government to regulate that?
Sure. I think it's authority that's common ground between us and petitioners, that the Commerce Clause gives the federal government the authority to regulate the channels of interstate commerce, including navigable waters, whether they're interstate or intrastate, if they could be used to transport commerce. That's within the commerce power. That's common ground between the parties. And then also, and this is the next step, that authority extends beyond just things that happen in the channels, but also things that happen outside the channels but could damage them. That's something that's been uncontroversial since the 1899 Rivers and Harbors Act, which extended up to tributaries and the banks of tributaries of navigable waters. And it's really necessary for Congress to be able to protect the channels of commerce, to also to be able to protect activities that affect those channels.
What is a channel of commerce? I'm talking about a purely intrastate, for example, a lake, purely intrastate. How does that get to be a channel of commerce?
So I'd point to the same case that my friend did. The Great Salt Lake was at issue in some litigation between Utah and the United States. And what the court said is, even though it's intrastate and there's no water connection to some out-of-state body, you could still move commerce across it, and that commerce could be moving in intrastate if you married up the transport over water with transport over land.
Is there a lot of transportation over the Great Salt Lake?
Apparently not. That's why it was in litigation, but the court held that a little bit from the 1880s was enough.
Thank you.
I guess there's less and less. Justice Alito?
Does your understanding of waters of the United States take into account any of the clear statement rules that have been invoked on the other side? For example, the effect on federalism, the fact that you're reading an awful lot into a parenthetical in 1344G. Your argument is that with this parenthetical, Congress did something that has major importance, and also the fact that there may be a vagueness problem. Do you take any of that into account?
I think, yes. I think those considerations are all reflected in this court's prior decisions, and we take the significant nexus test to be consistent with those decisions and to be a limiting construction, a narrowing construction on the covered waters that makes sure that the covered waters include all the waters that are necessary to achieve the goal that I talked about with Justice Thomas, and that leave waters that aren't essential to that goal to the states to regulate.
Okay, so it sounds like your understanding of waters of the United States is I come back to my earlier question, anything in the United States that has water in it, if it has an ecological effect on waters, on navigable waters. Is that right? And then these clear statement rules narrow that. That's your interpretation of the phrase waters.
I wouldn't say any effect is good enough. I think the concept is significant nexus from this court's cases, but yes.
Would you win if 1344G had not been enacted?
I think we would. I think the Corps of Engineers and the EPA got it right the first time when they said adjacent wetlands are regulated under the plain text of the statute. What 1344 does is that it tells you that Congress looked at this problem, considered proposals to cut back the act, and then essentially approved the Corps' interpretation in express statutory text while adopting other changes to the act to deal with some of the concerns that were raised.
Just out of curiosity, what is your understanding of the United States? Does that mean in the United States? Does it mean something else?
I think it means more than just in the United States. We take it to mean waters in which there's a federal interest, waters that affect the navigable waters that are where the federal interest is indisputable. We take it to be sort of reiterating that point.
That would extend very, very far, would it not?
It's true that the Act's coverage is broad. It's been understood as broad from the beginning, and that was Congress's intent, was to comprehensively regulate the waters of the United States because the prior system that relied primarily on states had proved insufficient, in part because this isn't a problem that the states can solve by themselves, because pollution that happens in one state or the destruction of wetlands in one state have consequences that may be felt in many states downstream that can't themselves regulate to address it.
Do you doubt that Congress could regulate dry land on the theory that it has a significant, together with other similar pieces of dry land, it has a significant effect on interstate commerce?
I think I would probably defend such a law, and I think the Rivers and Harbors Act was a version of that, which said you can't place refuse on the banks of tributaries to navigable waters because it could wash downstream into the navigable waters. But I think that's stretching out further, certainly, than Congress did here.
So if that's the limitation of the United States, it's not much of a limitation.
So, Justice Alito, I disagree, and I think the proof is sort of in the pudding. The agencies have told us in proposing to recodify the significant nexus test that we're defending here today that it has real teeth, that they routinely conclude that it's not satisfied, and that something like 25% of jurisdictional determinations made under the post-Rapanos guidance conclude that there's no jurisdiction under the Act. So I think that's real concrete evidence that this is broad because Congress's purpose was broad, but it's not unlimited.
What the agencies have done, I would imagine, is to take a very broad provision that can be read to give them almost plenary authority and make some pragmatic judgments about how far they want to go based on all sorts of factors. Is that unfair?
I don't think it's unfair in the sense that I think pragmatism, administrability, considerations of policy have factored into this rulemaking, I'm sure. But I think the thing I'd add to what you said is that the agencies have also been mindful, especially in the ongoing rulemaking, of the guidance provided by this court's decisions, which have significantly narrowed the agency's interpretation from where it was in the 80s.
Thank you.
Justice Sotomayor?
I just want to be clear. You're defending the significant nexus test with respect to use when it's not adjacent to navigable waters, correct?
That's correct.
But so are you giving up the argument that the Sackett wetland is covered by the Act simply because it is adjacent to Priest Lake?
So I didn't get a chance to get this out in response to Justice Gorsuch. What I wanted to say is the agencies do think and argued previously that the wetland is adjacent to the lake itself. The district court upheld that determination. We didn't renew that argument in the Ninth Circuit or in our briefs in this court. We relied on adjacency to the tributary and the additional showing of a significant nexus to Priest Lake. So that's how the case has been briefed and argued as it comes to this court. But if you're asking about the agency's view—
Why did you give it up?
I don't know why that decision was made. I would guess that it's because adjacency to the tributary is in some ways a simpler test. It's only 30 feet from the tributary, and because we felt confident that we could make this showing of significant nexus down to Priest Lake, it was this sort of simpler way to justify the conclusion that the property is covered.
Justice Kagan? Justice Gorsuch?
I just want to follow up on Justice Gorsuch's earlier questions because I think he identifies something that this court's overwhelmingly been concerned about for decades, mens rea, and not punishing innocent people who make a mistake, or innocent mistake. So what assurance can you provide on that front that some of the hypotheticals about someone being penalized for making a mistaken but reasonable judgment about the status of their land will not in fact be punished?
So I'd say a couple of things. The first one is this court made the point in Maui that the civil penalties provisions direct courts to consider things like essentially mens rea or culpability in deciding the amount of civil penalties. And as the court said there, it was confident that district courts would take that into account. In the agency's experience, they do. On the criminal side of the house, it's true that the 1319D of the Act does provide for potential criminal liability for negligent or knowing violations. As a matter of practice, the agencies tell me that it's very unusual to bring criminal prosecutions absent sort of willful conduct.
To state the obvious, that negligent provision is a red flag. So what do you have to say about that?
Yeah, understood. So I'd say two things. First, as a matter of practice, I think it's rare for a simple, in fact, very unusual for simple negligence to give rise to criminal liability. The criminal prosecutions are brought only when there's some sort of serious aggravating conduct. And the other thing that I'd say is, we think that standards like this, as reflected in County of Maui, where there was a similar multi-factor standard that also potentially gave rise to criminal liability, that didn't stop the court from adopting that standard. We think the same should be true here. And we think if you really had a case where there was someone who was being criminally prosecuted and had a claim that the statute was vague as applied to them, that they didn't have fair notice, they could always bring an as-applied vagueness challenge in the criminal prosecution.
Thank you.
Justice Barrett?
I want to return to Justice Sotomayor's point because I want to make sure that I understand exactly what the scope of your argument is. As you're arguing the case in this court, to win, we have to find that you're right about significant nexus, Justice Kennedy's position in Rapanos, because you're not really relying for purposes of this case on the 1344G adjacency language. Is that correct?
We're relying on adjacency to the tributary, which requires us to make a showing of significant nexus. So we do have to have both as we brief the case. But I think also it's worth emphasizing that petitioners aren't challenging the significant nexus finding. And also, I think they've conceded essentially that if you get past their idea that adjacent includes only things that directly touch, then their property is adjacent because it's only 30 feet away across the road.
Okay, and then to follow up on Justice Alito's points about waters of the United States, if we put aside 1344G for a moment, and we're thinking about significant nexus. Justice Thomas says he grew up in the low country of Georgia, and I grew up in New Orleans. The whole thing's below sea level. There are aquifers that run right underneath it. We have no basements because you dig far enough in anybody's yard, you hit water, and all of that runs into Lake Pontchartrain and the Mississippi River navigable waters. So would that view of the Clean Water Act and the definitions of waters of the United States mean that anybody who constructed on a lot or built a backyard pool has to get a jurisdictional determination from the Corps before proceeding?
No, I don't think so, Justice Barrett.
Why not?
Because these requirements all apply only if you're talking about wetlands, which has a particular scientific definition reflected in the regulations. It requires...
But your view of the statute wouldn't be so limited, would it?
The statute, we think, is limited to wetlands. We don't argue that things that don't qualify as wetlands can be waters of the United States. So
okay, and why would that be? Because of 1344G? Because nothing in the statutory definition of waters of the United States, if you're talking about something that has a significant nexus, presumably subsurface water would.
But we don't think you could call groundwater a water of the United States. We don't argue that groundwater is covered. To Justice Sotomayor's point, we think that subsurface flow can be evidence of a connection between two bodies of water, but you have to be talking about waters. We think wetlands like swamps and marshes and fens like the one at issue here are waters of the United States, or can be if they satisfy the test. And someone's backyard in New Orleans, if it doesn't meet the definition of a wetland, is not a water, even potentially a water of the United States.
But what about debris on the bank of the river, the example that you gave? So it's not on the river itself, but it's on dry land.
I took that to be a question about the scope of Congress's constitutional authority, and I was giving that as an example of the Rivers and Harbors Act in order to protect the channels of interstate commerce, the aquatic channels of interstate commerce, extending its authority up onto land. We don't argue that Congress has done that here. Here it's about waters of the United States.
So it hasn't used its full Commerce Clause authority, in your view, in the Clean Water Act?
That's correct.
Okay.
Justice Jackson? Thank you, counsel. Mr. Shipp?
Whatever the deficiencies in the line drawing problem test, they pale in comparison to the significant nexus test. In response to Justice Thomas's question about the channels of commerce, the significant nexus test is far, far broader than a traditional understanding of the channels of commerce, as shown by this very case. The Sacketts, there's no evidence that anything the Sacketts did affected any channel of commerce. It's the mere fact that they put gravel on their lot that now they're fully regulated under the Clean Water Act. And that raises Justice Alito's point about canons of construction and federalism. Building a single-family home in a residential subdivision is the quintessence of local government authority, and yet the significant nexus test inevitably causes that to be regulated. JDs are expensive. There is an entire industry of environmental consultants whom one has to hire to fill out an adequate application to the Corps. Sure, the Corps doesn't charge you, but your consultant will definitely charge you an arm and a leg just to have a chance to find out whether one is in fact regulated.
Counsel, can you just speak to the representation that was made about the Sacketts property in particular and the fact that prior to their purchasing it, there was some concern about the property being a wetland? Did I misunderstand that? I thought they went into it knowing that this might be a wetland.
No. There was a jurisdictional determination done in 1996 by a prior owner. The Sacketts were not aware of that.
Would they have been as a part of the purchase agreement? Shouldn't they have gathered information about the property prior to purchasing it?
Justice Jackson, in the record, the Sacketts' testimony is that there was no indication either from the county building department in their deed of title anywhere that this was a wetland. Moreover, even if they had been aware, that jurisdictional determination would have given them no comfort because—
But did they see the property? I understood in the pictures that you could tell that at least part of it was a wetland by looking at it, so—
I believe Mr. Fletcher was referring to after the initial work had been done, and the pictures show that there's water on the property, but that doesn't show how it was before. But if I could go back, though, to the question of the jurisdiction—
But you keep talking about notice and fair notice and property owners not being able to tell or know about this issue, and I'm just trying to clarify with respect to the Sacketts. There seems to have been a prior determination that the land was wetland before they bought it, and whether or not they knew, they could have known, I presume. So why is this unfair in this situation with respect to the government now asserting that authority?
Justice Jackson, that determination had expired several years before the Sacketts even purchased the property. As Mr. Fletcher explained, typically jurisdictional determinations are only valid for 5 years. Moreover, that determination was done even before this Court's decision in Rapanos. So even if the Sacketts had been aware of it, it would have given them no notice whatsoever.
We'll give you an extra minute for your rebuttal.
Thank you, Mr. Chief Justice. The last point I'd like to make is with respect to compensatory mitigation, simply that obtaining a permit is a very expensive process. It's true that the Corps does not charge for permits, but the Corps will never give a permit unless one provides compensatory mitigation. And we cite studies from the amicus briefs at pages 20 and 21 of the Yellow Brief, where the annual cost of compensatory mitigation under the Corps program is in the billions of dollars. This is not an easy process. It's not a cheap process. And in terms of notice, it's not a fair process for property owners who have to deal with the significant nexus test, which is why this Court should definitively jettison that test.
Thank you, counsel. The case is submitted. Your argument next in Delaware versus Pennsylvania and Wisconsin and the consolidated case. Mr. Katyal.
Thank you, Mr. Chief Justice, and may it please the Court. This case concerns a piece of statutory text from 1974 in Section 2503, which is found in the Blue Brief Appendix at page 2A. That provision exempts from the common law a narrow set of instruments, a money order, traveler's check, or other similar written instrument other than a third-party bank check. The question today is whether two products, MoneyGram agent checks and MoneyGram teller's checks, fall within that exemption. For many years, the defendant states answered that question no. However, after engaging some creative consultants, they changed their mind. They were right the first time for four separate reasons. First, when Congress adopted that language in 1974, the term money order referred to specific commercial products labeled money order and typically sold to unbanked consumers to pay small debts. Neither of those apply to the two disputed instruments here. They're not labeled money order, and they are sold to consumers with bank accounts who are transferring larger sums of money. Second, the FDA was a surgical fix to this court's 1972 decision with a key purpose behind it to prevent the price of small dollar instruments from increasing due to address collection requirements that states might adopt in reaction to this court's 1972 decision. That rationale does not apply here, and the two instruments are outside of the FDA altogether. Third, even if you thought these products were within the FDA, the two instruments here fall within the third-party bank check exception. Like all bank checks, they are signed by bank employees, not purchasers. And fourth, while we believe that our reading is the best reading of the FDA's text, structure, and purpose, we don't deny one could read the statute differently. But importantly, if you found things in equipoise, two things would independently break any tie for us. One is the doctrine of reading statutes to avoid derogation of the common law, and the other is this court's repeated emphasis on the need for bright-line rules and predictability in this space. The defendant's interpretation would upend all that, as their own amici acknowledge. Our view of the statute, by contrast, is predictable, reflects long-standing practice, and provides a bright line for the escheatment of financial products in the future.
Mr. Katyal, how much weight do you put on this money order designation? What if tomorrow morning they simply stamp the top of these the two disputed instruments money order, commercial money order? Would that solve your problem?
So, Justice Thomas, that if they change the label, we do think that it would mean it's not a money order or a traveler's check. So we do think you look to the label for that. And indeed, I think that's what they say about traveler's checks. But we don't think it would be true for other similar instruments. So we think that in your hypothetical, in which you have the exact same instrument, but it has just a different name on it, that is an other similar written instrument. Notably, that's never happened. And the reason is because money orders and those labels are important for consumers and for banks. They want to know what they're getting. They want to know what they're selling. And that's why they can't point to a single example where that label has ever been stripped off. But I agree with you, Justice Thomas, if that happened, that would fall within the FDA, your hypothetical.
Well, can you point to any reason in the past why this definition of money order is so narrow? It would seem to me that over time, it's not necessarily, as you say it is, a discrete set of instruments.
So we don't doubt, Justice Thomas, that there is a way to define money order as broadly as my friends on the other side do. If you do that, it blows up things like cashier's checks, certified checks, all the stuff that the American Bank Association is warning you about, and that Judge LaValle couldn't get around because he just said, I'm not going to define it.
One final question, and I'm sure my colleagues will have more, but how do you get around similar the similarity language? It seems as though all of these are drafts, and that if you say, well, it's not a money order, it looks like a money order in many other ways. So why does it not fall into the similarity category?
Yes, Justice Thomas, we don't think it falls into the similarity category. We think that's for things like what you were talking about before in your first question to me, where the name isn't there, and possibly some other things. But here, there are three things about these disputed instruments which aren't true about money orders. First, you can only buy disputed instruments at a bank. Money orders are sold typically at retailers, CVS, Walmart, and the like. Second, you will have a bank account when you buy them. And third, the third point is that the money orders, that money orders aren't signed by the bank, but these two disputed instruments are. Now, I know that sounds formalistic. Here's why that matters. Because Congress and the FDA was worried about what this court invited states to do in 1972, which is to impose address collection requirements on money orders and traveler's checks. And what they said is, these are small denomination instruments. If you do that, it's going to increase the price of them. The disputed instruments, because there is that bank account and because you're going into the bank, that address information is already being collected now. So if you're worried about my friend's point about equity and the windfall to a particular state with respect to these disputed instruments, the states have the easiest fix in the world, a fix they didn't have in 1972, which is to say, whenever you're one of those banks dealing with MoneyGram, you just have to transmit the address information that you're already collecting.
But counsel, you suggest that Congress's concern was the collection of address information. If that was so, they certainly did a weird thing in terms of the statute that they wrote. I mean, the statute did not just say collect the information, which would have solved the problem directly. The statute seemed to take into account the fact that there were going to be circumstances in which that information was not collected, and Congress appeared to be trying to override the common law with respect to what happened because it was really concerned about inequitable escheatment. And so my question is, to what extent do these disputed instruments present that problem? Because if we believe that that's what Congress really cared about, then why would they have crafted a statute that excluded certain instruments that presented that same problem?
Yeah, Justice Jackson, we don't think that that windfall concern, that equity concern, applies to the two disputed instruments. So Congress in 74 was worried about address collection requirements. They said, we want to head that off because that's going to increase the price of travelers' checks and money orders. That's why they didn't write the statute that you were saying, which is to impose address requirements. The findings in 2501 say, no, we want the reverse, because if states start doing that, it's going to increase the cost of those instruments. And so that concern doesn't apply to the two disputed instruments here because the address information is already being collected. And then when you're concerned about the equity that still exists with respect to these two disputed instruments, because Delaware has them, not for all bank checks, obviously. Bank of Americas of the world and Citibanks are really the largest cheaters in this space. But with respect to the two disputed instruments, to the extent that states, including my friend's states, if they're worried about the equity, they have the simplest and easiest fix in the world, which is to just require that the information when you go in and buy a teller's check or an agent check is issued, it just has to be transmitted to MoneyGram. And if that happens, Justice Jackson, then you avoid this whole equity about state of incorporation, because then the primary rule of the common law would apply, which is the creditor's last address.
You can only do that with respect to your own state, right? I mean, every state would have to adopt that rule in order to solve the problem, and Congress, it appears, wanted to solve the problem in a different way.
So certainly Congress could solve it nationally, and this court, in Justice Thomas's opinion in Delaware, invited Congress to do that with respect to the inequities and windfall that it said wasn't enough to justify this court departing from the common law. And then you're absolutely right, Justice. Any state that is concerned about the inequity can pass a law, and I think it's probably a pretty easy law for them to pass because, quite honestly, they're just getting extra money. And so it's up to them. What my friends are asking you to do is to basically break from the common law and because of their policy concern. And that is exactly what this court has said every time, and most recently in the Delaware case, that you don't do. And here's why it's so dangerous. My friend pitches this as a case about the dueling secondary rules, about place of incorporation versus principal place of business. That's what happens if you don't have addresses. But if you adopt his interpretation, you're also blowing up the primary rule. So the primary rule, there's a big dispute between a big gulf between the FDA, this act, which moves away from the last creditor's address, which is the rule of the common law. And so,
you're not reading that to be Congress's attempt to break from the common law. You're suggesting that what we do here is going to blow up the common law, but I had understood that the statute itself was trying to set out a different set of parameters than what existed in the common law.
Oh, absolutely. We don't doubt that they did that with respect to traveler's checks and money orders, but there's no indication that they went beyond that. And we think you should read that narrowly, because the entire reason they wanted to move away from the common law with respect to these two instruments is because of the inequity and the addresses not being collected, which would increase the cost of those items. Those don't apply. Those policy rationales don't apply here. And notably, Justice Jackson, Congress in 1974 knew exactly how to write the statute that you're asking for to get rid of the common law for a broader set of instruments. If you look at our blue brief at page 31, it quotes the 1966 Model Act, Uniform Act for the Disposition of Unclaimed Property. And that text is, quote, any sum on which a banking or financial organization or business association is directly liable, including, by way of illustration, but not of limitation, CDs, drafts, money orders, and traveler's checks. Now, the first part of that statute that I just read to you is exactly the language from 2503. Indeed, Judge LaValle below said it'd be the most extreme coincidence that you'd use all of the same language from 1966 and the FDA. But what isn't in there? Everything about by illustration, by way of illustration, but not of limitation. The enumeration of other financial products, like certificates of deposits and the like. And so Congress is telling you here in this statute, we mean traveler's checks, we mean money orders, and Justice Thomas, absolutely, we mean other similar written instruments. But that can't be everything that is prepaid the way my friends would have it.
If someone purchases an agent check or a teller check, what information about that purchaser does the bank transmit to MoneyGram?
None. That's what the record says.
Nothing.
They collect the information, but it's not transmitted. And so the record, like at our appendix, page 599, says the information is collected.
Well, they have to tell MoneyGram something.
They don't tell the actual the name of the payee or the address of the payee, the relevant information here. And Justice Alito, your opinion in the Yee case talked about the concerns about escheatment and about people not getting due process and the like. And to the extent you're concerned about that, our rule, the common law rule, incentivizes precisely that state solution, because states will then say, look, if you want MoneyGram, if you want to come into our state, you got to transmit that information and close this informational hiccup. That's what our surreply at pages 22 to 23 goes through. So that means MoneyGram will now be under a duty to go and find those people and say, you know, here, there's this abandoned check. And if they can't find them, even with the address, then that information all goes into the state unclaimed database. And then you can search by name and address.
Well, you make the,
I'm sorry, go ahead.
You make the fair point that the states could require the banks to transmit this information to MoneyGram. But just out of curiosity, why doesn't MoneyGram ask for this information? Would that cost a lot of money?
Right. The record doesn't say. I suppose it probably does cost a little bit of money, and MoneyGram's indifferent to this whole question. And the American Bank Association brief at page 1 says that, look, that these companies are generally indifferent to these things. So it's a very easy statutory fix, because states will get money that they otherwise wouldn't get. And that wasn't available in 1974. That's what makes this case so different from the 1974 FDA, because there, and Congress specifically, as I was saying to Justice Jackson in 2501, made a specific finding: address information's not being collected for traveler's checks, not being collected for money orders, and if you impose that requirement on those small dollar instruments, it's going to increase the cost. These are, of course, large dollar instruments, and so the money is much larger, and so there's a much better incentive, particularly for the reasons, Justice Alito, you wrote about in Yee, to try and collect and find the rightful owners of this property.
How much? What's the comparison in terms of total value? I mean, I understand your point that the traveler's checks, the money orders, small amounts, the official checks, the agent checks, and the teller checks, not limited. But how many of each are there? Where's all the money? Is it the money orders and traveler's checks, or the big bank checks?
Yeah, Your Honor, unfortunately, the record, I don't believe, gives us any quantification of that. We do know that in 1974, the typical money order was between $1 and $25, and there's other evidence about that. And even up to today, MoneyGram, for example, limits money orders to $1,000.
Yeah, but the question there, I guess, is how many of them there are.
Correct, and we don't have information about that. I think Congress wasn't concerned as much with overall dollars as they were with the small denominations and the fact that address requirements would impose a much bigger burden compared to the benefit you'd get. Whereas here, I think for these things, teller's checks existed in 1974. Bank checks and, agent checks existed just by a different name in 1974. Congress pointedly didn't enumerate any of that in the statute. They used, to use Justice Gorsuch's convoluted phrase from the first argument, convoluted. Sorry, Justice. You called Congress's action in the last argument convoluted, and I think that's right here. That if their argument is right, Congress chose a really weird way of going about it.
All right, I was sitting here quietly, but now you've drawn me out. Other similar instruments, the language Justice Thomas, I got a question. Fine, I'll come up with one. All right. What does it mean on your account? And on page 44 of your brief says that Congress likely intended the term other similar written instrument to capture alternate spellings of money order and traveler's check, such as American Express traveler's check, QUE. Okay, now I am familiar with various spellings of traveler's check. I am not familiar with various spellings of money order. Help me out.
Yes. So one category is exactly what Justice Thomas began the argument with, which is a money order in every way, shape, and form, except it doesn't have the label on it. So argument is not limited, Justice Gorsuch, to different spellings. Same product without the label is what an other similar instrument is. That's one category. Another category are things, I think, generic products. So just like a copy is called a Xerox, I think Congress in 1974 was worried that a traveler's check might be called an Amex, or worried that a money order might be called a Western Union. That's a second category. And then a third category of other similar instruments are some of the things that have been bandied about in this litigation and in the briefs. So there's something called an agent check money order. There's something called a personal money order. That's in our appendix at page 381. There's something called a bank money order. There's
I take your point. Yeah. Okay. But does it underline another point that may be problematic? And that is that labels cannot control substance in our analysis here. Can we agree on that?
We do.
Okay.
And so our point is labels are very good at deciding traveler's check, money order. And they're good not just for courts.
Well, I guess I'm wondering why they're good for some purposes but not others.
Because I think it reflects Justice Gorsuch.
You don't like labels when it comes to this little exception here.
Oh, it's not that we don't like them.
But if I might just finish, and then have at it, okay? But you admit that labels can't control for some purposes. But yet you do ask us to place quite a lot of weight on money order versus traveler's check otherwise. And so I'm stuck there. So help me out. So
we think that labels matter because they're not just for courts. They're, after all, for banks and consumers. Banks have to figure out, what is this product and which state do we escheat it to? And labels are a really good way to do that, as opposed to some convoluted 8-factor test where you got to have law professors testifying about experts about whether something is a money order or not. So we think labels in general work, but Congress was concerned about more than that, and that's what I was saying to Justice Thomas. And so that's what other similar written instrument does. It's labels for the first part, but not for the second part. And I think Congress in 1974 had examples of statutes in which other products were enumerated. So our brief cites, for example, 26 U.S.C. 6311, which is a 1970 statute which refers to, quote, any certified treasurer's or cashier's check or any money order. I think demonstrating that Congress thought money orders were distinct from these other products. If you adopt my friend's interpretation, cashier's checks, certified checks, all of those become money orders because they are all instruments that prepay money. And as the American Bar Association brief says, that's going to be a disaster because millions and millions of dollars, and there's a little, at least there's some hyperbole, or not hyperbole, there's some subjective quantification of this in the ABA brief saying that that is incredibly damaging and destabilizing to the financial sector because this has all been around and done a certain way since 1974.
So I guess I didn't understand until argument that you're saying that money orders is an only label test. Is that right? And then the similar instruments is where the characteristics of money orders come in. Is that right?
Correct.
And then what are the characteristics of money orders that you're pointing to? Like what does some other non-labeled instrument have to comply with in order to be determined to be a similar instrument?
Well, I do think it'd be a transfer of information in which address information isn't being collected and a small denomination kind of instrument. And so here, there's a wide gulf, however you define similar, between the two disputed instruments and agent checks and teller's checks, traveler's checks, and money orders. And the three things are, number one, in order to get a disputed instrument, you got to go to a bank to get it. Second, you will have a bank account when you do so. And third, it's got to be signed by a bank employee. And that's a pretty important distinction because when something is signed by a bank employee, it makes the bank liable for the piece of paper, as opposed to money orders, which are limited recourse documents. And you can't sue the issuer of a money order the way you can the two disputed instruments. So we think those are three hallmarks. Does that solve
it? I mean, it feels as though you're picking things that, as you should, that make you succeed in the case. But I could pick three other things that make Arkansas succeed.
We're not just randomly picking these, Justice Kagan. That goes to, I think, Justice Jackson's question to me earlier, which is the purpose behind this, which is the address information isn't being collected. It's burdensome to do so. That's a statutory finding, and the equity windfall considerations. Here, for these disputed instruments, the states have the easy fix available to them that wasn't available to them in 1974. Because if states did what this court invited them to do in 1972 in response to the windfall concern, it would increase the cost of those instruments and be problematic. And so that's why Congress said, we're heading it off for those instruments, but not for these. And these factors that I'm referring to you are relevant to that because they show address information is being collected for the disputed instruments, not being collected for traveler's checks and money orders. That's the key difference between the two.
Counsel, the MoneyGram treats one of its other official checks, the agent check money orders, as subject to the FDA. Justice Thomas asks you, what happens if they remove that tomorrow? Under your test that you just articulated to Justice Kagan, then it would go back to not being a money order.
No, Your Honor. If I understand your question, it's the same instrument. It just doesn't have the label money order.
They take it off.
Yeah. If they take
it's
it
issued
off,
it's issued by a bank, right, not a retail operator. They do collect information, don't they?
For agent check money orders, I think some information is collected, yes.
All right. And what was your third criteria?
That you have to have an account at the bank.
And they have an account.
They may have an account at the bank.
So
with respect to that, limited universe, we even there, I guess I should say, Let's look at that, Justice Sotomayor. It's at page 230 and 231 is an agent check money order. And so what it says on the front is that there's a picture of it, and it says on the front that, that it's labeled agent check money order. And then on the back it says, if the instrument is designated on its face as a money order, then the following applies. And it says it's limited recourse. Now, if you strike that off from the back, then I think you are fundamentally changing the nature of the document, because you're making it now not a limited recourse document. You're making it something else. And so that actually has a substantive change. I think it's a different, and the reason that's why I'm going through this, because it's different very much than Justice Thomas's hypothetical. So our view on this is generally labels will control. In some circumstances, if you have the very same product, just not the label, then that is another similar instrument. But for your question, which is actually changing the meaning of the document itself, then that isn't one that is an other similar written instrument.
Thank you, counsel. Justice Thomas, any further? Justice Alito?
You say that a third-party bank check is a check that is effective on the signature of a bank officer, but isn't it the bank's liability and not the signature that makes an instrument a bank check? The signature merely indicates that the bank is liable.
No, Your Honor. I think the signature is the thing that does make the bank check actually effective. And we point you to Munns, which we cite to in our brief, for exactly that. And I think your question is really important because Judge LaValle said, well, I'm going to look to the Hunt Commission to determine what a third-party bank check is. And a third-party bank check, he says, according to the Hunt Commission, is a personal check. But actually, the Hunt Commission says that's just one example. And notably, really importantly, at page 41 of our brief, we say, if you go on and read what the Hunt Commission says, it actually says teller's checks are third-party bank payment systems. So the Hunt Commission invocation boomerangs on them. It underscores that the types of disputed instruments here, these teller's checks, are third-party bank checks. Congress was worried about these larger dollar products like teller's checks, and they specifically exempted them. And so even if you didn't buy anything that I've been saying for the last 25 minutes about we're not falling within the FDA at all, we would fall within the third-party bank exception. We don't think you have to get there, of course.
Whether a bank employee signs the check or not is a formality. What is the effect of that?
We think it's more than a formality. We think that is actually the relevant characteristic that Munns, Wallach, and Lawrence all say that makes something a bank check. You look to that. Now, admittedly, it's not the clearest of phrases, but we think that's the one that gives it some meaning and reflects Congress's 1974 knowledge. Teller's checks were around in 74, and yet Congress didn't enumerate them in 2503, much more narrow statute than the 1966 one.
Thank you.
Justice Sotomayor? Justice Gorsuch?
Just to pick up quickly on Justice Kagan's earlier question on similar written instrument, that's kind of a statutory version of justum generis, I suppose, and we're always trying to figure out what the key features are. Why aren't the key features here? Prepaid money transmission product, doesn't show last known address of purchaser, and the windfall purpose is implicated. So you have arguments, but why aren't those the better features to focus on when we're figuring out what similar means here?
Because if you do that, you blow up the statute to include cashier's checks, certified checks, and all sorts of stuff that Congress knew exactly how to name or to write open-ended statutes and didn't. And so to us, going back to the statutory interpretation question, it's like a statute that said, rubber bands, paper clips, or other similar items. So, yes, could you find some commonalities? Sure, but I don't think it means other all-office products like desk chairs or paper or things like that. You're looking for something more narrow, and as I said to Justice Jackson, the statutory findings give you what Congress was thinking about here in terms of address collection and the burdens.
Thank you.
Justice Barrett? Justice Jackson?
Yes, just one question that is confusing me. You keep suggesting that larger dollar products are exempted from the statute, things that would be covered by like the disputed instruments. They deal with larger dollar and money order, smaller dollar. What I don't understand is why that's the case. I've heard you say that there would be an incentive to include address information for larger dollar products. But if that's true, then under the common law, we wouldn't have the inequitable escheatment problem. So the fact that the states are fighting about these disputed instruments indicates to me that the disputed instruments don't have addresses on them, which undermines your argument that larger dollar products would necessarily carry with them the address information. Do you understand what I'm saying?
Absolutely, Justice Jackson.
Yes.
So the record is clear on this, and I don't think my friends on disagree that for the disputed instruments, address and pay information is being found. That's our appendix at page 599. It's the ABA brief at page 22. Our appendix also at page 400, and quoting even from 1956, the ABA report. The reason why it's being collected has everything to do with money laundering requirements and the like. 31 CFR 1010 requires collection of this information for anything over $3,000. The informational hiccup is the information is being collected, it's just not being transmitted to MoneyGram. And that's where the states have a simple statutory fix. They're asking you to do their hard work for them. And if they did that statutory fix, it'd be prospective. It wouldn't jeopardize everything that's happened since 1974, in which a state like Delaware has collected, money under a certain set of escheatment rules, and they want to unwind all of that. And that would be very destabilizing, not just for the products at issue here, but certified checks, cashier's checks, as the ABA says.
Thank you, counsel. Mr. Brawny?
Mr. Chief Justice, and may it please the court. This case presents the problem the FDA was enacted to solve. In Pennsylvania versus New York, this court concluded that unclaimed financial instruments escheat to a purchaser's state of residence, or if that's unknown, to an issuer's state of incorporation. Because issuers of certain financial instruments rarely kept purchaser addresses, that meant a windfall for an issuer's state of incorporation at the expense of its fellow states. Just 2 years later, Congress responded to that inequity by enacting the FDA. That statute says that where addresses aren't typically kept for a class of instruments, those instruments escheat to the state of purchase. Now, 50 years later, Delaware claims that it's entitled to the exact same sort of windfall that led to the enactment of the FDA. To justify that, it argues that the FDA doesn't cover instruments that function precisely like other money orders, but are marketed differently. But marketing strategies do not define commercial instruments, and they don't justify $250 million windfalls. Recognizing the weakness of that argument, Delaware alternatively claims that MoneyGram official checks are excluded from the FDA as third-party bank checks. That argument fares no better because MoneyGram is not a third party, as that term was used in 1974, and MoneyGram's official checks are absolutely not bank checks. Nor, for that matter, does Delaware explain why Congress would have chosen to exclude instruments that present precisely the windfall problem that the FDA targeted. So it's hardly surprising that all three payment systems experts in this case, including Delaware's own expert, agreed that under any ordinary understanding of the phrase third-party bank check, MoneyGram official checks are not third-party bank checks. So we would ask this court to overrule the exceptions and adopt the special master's recommendation.
Mr. Brawny, would you spend a few minutes on Mr. Katyal's parade of horribles if we accept your argument?
Sure, Your Honor. I think it's probably easiest to begin with the example of cashier's checks because there's been a lot of ink spilled on the cashier's check issue in this case. And for that one, we don't believe that cashier's checks are necessarily covered by our definition. So to begin with, our definition requires that an instrument be prepaid. A cashier's check as a class of instrument is not necessarily a prepaid instrument. Instead, as the ABA's amicus brief argues at length, there are many frequent, common, ordinary, everyday situations where cashier's checks are not prepaid.
So for instance, if a bank needs to pay its own obligations, say it needs to pay an electrician or meet a tax bill, it will issue a check drawn on its own accounts. That's a cashier's check. That is not a prepaid instrument. If the bank needs to disperse loan proceeds, it will issue a check drawn on its own account.
So does that mean we determine cashier's checks one by one, depending on whether it's prepaid?
No, Your Honor. I think this is one of the reasons why we're judging things sort of on a class of instruments. And as a class of instruments, in contrast to official checks and money orders, these are not always prepaid. So that it's a class-wide distinction. But even aside from that, there are other reasons why we believe that cashier's checks, even aside from our definition, would not be swept in under the term money order. And one of those reasons is, I think, as Justice Thomas, your question reflects, so there are instruments in the world that people would not describe as money orders, even if they share some of the common core features. And a cashier's check is a good example of that. We would not, in ordinary parlance, call a cashier's check a money order because it is a unique instrument and that it's issued by the same bank, drawn on that same bank, which makes it a uniquely secure instrument that is different. So in ordinary English, it's a well-known instrument, as Delaware agrees, as the American Bankers Association agrees, and that's a justification for carving it out. And then finally, another reason why we would think it wouldn't be covered is because in 2501, when Congress is describing money orders as a class of instruments, it describes them as a class of instruments for which addresses are not ordinarily kept as a business practice. That does not describe cashier's checks in 1974, and it doesn't describe them today.
Why does it describe the disputed instruments? Your opposing counsel says the disputed instruments are a class in which the addresses are typically kept.
So I think that sometimes the addresses, I think what the record actually reflects is that sometimes the addresses are collected by the selling financial institution, as could be true, frankly, of a retail money order. So that the statute my friend was referring to is a requirement that if you sell at least $3,000 worth of these instruments or a retail money order, you're required to collect information and maintain it as the seller. That information, however, is not transmitted to MoneyGram. MoneyGram has a policy. It will not accept that information. It will not keep it. So what that means is the issuer, which is the actual holder of the funds here, because it's not the selling bank that holds the money. The day after a transaction takes place, that money is transferred from the selling financial institution to MoneyGram. And it's MoneyGram that holds that.
Well, but MoneyGram you can require MoneyGram to ask for that information. I mean, that would solve your problem just like that. Because just like with respect to the others that you say have to be covered and keep the existing or keep the address and purchaser information, MoneyGram would, and then all of that stuff would escheat to your state rather than Delaware.
I think, Your Honor, that the reason why our states have not necessarily done that is because I think Congress really, when it passed this statute, put its thumb on the scale and suggested that keeping that kind of information and having to maintain that information, which my friend on the other side admitted would be a burden, Congress decided that was an unnecessary burden. Now, Delaware suggests it would only be an unnecessary burden for low-dollar instruments, but that's not actually what Congress said. What my friend on the other side is referring to are things like floor statements, where certain members of Congress expressed a concern that by requiring address keeping, you could affect the utility of these instruments by driving up their cost. And there are floor statements that reflect that for low-dollar instruments. But what Congress actually said, all of Congress, in 2501, in the findings of facts, was not that. Instead, it said address collection and maintenance would be an additional burden that is not justified because most of these instruments are purchased in one's home state. And
well, just to be clear, there's nothing in the law that prevents you from requiring MoneyGram to ask for that information.
That's correct, Your Honor. Our states can...
And that would give you everything you're looking for here?
It would potentially for prospective relief, but not necessarily for...
You said in your opening that the difference between the instruments that we know are covered, money orders and traveler's checks and the others, is simply a matter of marketing strategy?
Yes, Your Honor.
But your friend points out that money orders and traveler's checks, on the one hand, are low value, high volume, purchased anonymously. On the other hand, the agent and teller's checks are high value, or at least not limited generally. They're not anonymous. They're drawn on an existing bank account, and they're signed by the bank. Now, that seems to be a very different than just a marketing strategy.
So, Your Honor, I think what Delaware has described there when it's describing money orders is really one segment of the money order market. I don't think that it's accurately described the money order market, certainly as it existed in 1974. So Delaware's own sources that are reproduced in the appendix, for instance, the American Bankers Association report on money orders from the late 1950s, or the Compton's Encyclopedia, which is also reproduced in their appendix. They do discuss money orders, yes, as a product that was frequently sold in low dollar amounts at retailers, oftentimes unbanked customers. Although, again, low dollar amounts and things like that, there is some equivalence over that because, as Judge LaValle pointed out, going back to 1939, Western Union, in fact, sold money order products denominated up to approximately $3,500, which, if we adjust for inflation, is about $25,000 today. So hardly a low dollar instrument.
Well, what was the value of the typical value of the agent and teller's checks?
These products did not exist, these specific products did not exist in 1974. So teller's checks as a class of instruments, a traditional teller's check did, but the instruments, MoneyGram labels...
I'm sorry, I slipped. They didn't exist in 1974?
The MoneyGram products that we are talking about here today, correct, did not exist in 1974. But if I can return to the distinction about the category of money orders for a moment, they describe them again. Their sources do describe them oftentimes as low dollar instruments, but those same sources also describe money orders as instruments that were also sold at financial institutions in the 1970s without those low dollar limits, and obviously weren't aimed primarily at unbanked customers. So their description of the category of what constituted a money order in 1974 is simply not accurate, even on their own sources. Yes, they've described one segment of the market, but that's not the entirety of the market. Congress did not say personal money orders or low-dollar money orders. Congress said money orders, and that category in 1974 included instruments sold at financial institutions, and today the agent check money order, which operates precisely like the instruments at issue here, yet it's only sold at financial institutions in high dollar amounts, primarily to bank customers, they admit that's a money order. But it lacks all of the things that they say define what a money order is, except the label. So this was Justice Thomas's question. Their argument is essentially if you take the label off, it's no longer a money order, even if you change nothing about the instrument. So a good example of this would be the Western Union example. If Western Union tomorrow made a decision that it was going to relabel its Western Union money order as the Western Gram, it would be Delaware's position that that's no longer a similar written instrument, or that's no longer a money order.
I guess I'm not quite sure I understand. Do you disagree that the agent checks and the teller's checks are typically, generally, whatever, for significantly higher value than a traveler's check?
Just like the agent check money order could be, Your Honor, because it doesn't have a limit. So yes, they are typically bought in higher amounts, but we don't think that that's really a substantive...
Okay, but that is, he's suggesting that as a distinction. Do you disagree that the agent checks and the teller checks are typically drawn on existing accounts while the traveler's checks are not?
Again, because they're bought at financial institutions, people will oftentimes buy them where they do their banking. I agree with that. But the drawn-on language is not actually correct there. Instead, what you're doing is you're prepaying for an instrument. You may deduct the money from your account, but it's a separate financial instrument. So it's not like an ordinary check, for instance, is drawn on your bank account. These instruments are not drawn on anybody's bank account.
If money order is as broad as you're saying it is, what's left for similar instrument?
I think, Your Honor, when Congress uses phrases like money orders, traveler's checks, and then follows it by a catch-all, I think what that oftentimes reflects, as this Court has said, is Congress is concerned with covering the field and not leaving any loopholes. So it may very well be that in 1974 there wasn't a product that existed that wouldn't meet the core definition of what a money order is.
It was just like a in case.
I think...
Just in case something comes up or we miss something or whatever.
That's one way of looking at it. The other option is it's to ensure, if you accept Delaware's frontline argument, to ensure that you can't simply change the label on an instrument and have it be something.
Yeah, but it might be, right? I mean, I think that this is the strength of Mr. Katyal's argument, that they were thinking of something called traveler's checks. They had used traveler's checks. And they were thinking of something called money orders, like the prototypical things that the Chief Justice was talking about. They had seen money orders. They had used money orders. And then they said, you know, maybe there's some stuff that functions in the same way, that does pretty much the same thing, that has similar characteristics, whatever the relevant characteristics are. So we'll put that third thing in, you know, other similar things. So that seems to me a a more likely way of drafting? It's like you have a particular product in mind and another particular product in mind, and then you realize that there are products you don't know about that might function in the same way.
And that is, we don't disagree that that's a possibility for what happened here. I just think that the way Congress when it used the term money order in 73, yes, we might now today typically think of an instrument that's sold at a retailer, but the fact is Delaware's own sources describe money orders as instruments sold at financial and non-financial institutions and that did not have low dollar limits. So I think they are money orders, as Judge LaValle said, under any common ordinary understanding, but I agree that at a minimum, they are certainly similar written instruments because they operate precisely like the instruments that we all agree are money orders. And if I can address briefly one of the labeling points that I think the other side made, that they pointed out, people, generally things are labeled consistent with what you would think they would be. And I think that's right. They don't identify another product sold by another institution that works like these. And that's because this is basically a product where money order had a business model of selling money orders, and it didn't want to alter the structure of how it does things. So it put a different label on it and sold it somewhere else in order to appeal to a different end of the market without fundamentally altering the product itself, because they still operate exactly like money orders. Just like a retail money order, you go in, you prepay for it, you get a written instrument in response. The selling financial institution is merely an agent of MoneyGram. It's not a party to the instrument. It's an agent of MoneyGram. And the day after a transaction takes place, it forwards the money to MoneyGram, the selling financial institution does. At that point, whether we're talking about their so-called teller's checks or agent checks, that selling financial institution is entirely out of the transaction. It has no more role. That is the same role that Western Union played on classic money orders in the 1970s.
Can I mention a number of different things and ask you to tell me whether you think they are subject to the FDA? So the first one is a conventional cashier's check or a teller's check issued by a local bank and used to pay its own obligations.
So I would say it's under our definition, it doesn't meet our definition of a money order. We have not taken a position necessarily on whether it's a similar written instruments, but I think that there are reasons for believing that it is not, because again, that is not an instrument that would present the windfall problem as Your Honor framed it.
And what about a conventional cashier's check or teller's check issued by a local bank and sold to a bank customer? Same thing?
Yeah, again, Your Honor, they would typically keep addresses. In 1974, certainly for cashier's checks and classic teller's checks. If I can briefly just add to that, because we've talked about teller's checks a lot, these instruments, I know I've said this, but to make clear, these instruments are not traditional teller's checks. They label them as teller's checks, but they do not operate like traditional teller's check. So a traditional teller's check, as it existed in the 1970s, was an instrument, yes, signed by a bank officer. They're right about that part, and they stop reading basically at that point. But the rest of the definition is signed by a bank officer drawing on funds of his bank at another financial institution. The difference with these items is that's not what's happening here. The signing officer is not drawing on funds of his own bank anywhere, which also indicates that they don't even meet the definition of bank check.
But are they still liable in the teller's check realm?
So there is some jumbling of the record on this point, unfortunately, Your Honor, but I think what Delaware's expert ultimately said is at most they might be secondarily liable, but the ultimate liability with the so-called teller's check instrument is MoneyGram, because MoneyGram is the issuer. How about a prepaid cash card?
Some grandparents always used to send their grandchildren a MoneyGram for Christmas. And now they want to become more modern, so they send them a prepaid Visa cash card.
Not covered either as a money order or a similar written instrument because it has to have a named payee, and gift cards do not have named payees.
How about a gift certificate that does have a named payee?
I suppose it's possible if that instrument were a draft. There's not really any record development on this point that we could quibble about that, and I know that there are some states that do cover instruments that have statutes that would cover a sheetment for instruments like that. The reason why I'm struggling with that one is I don't know all the characteristics of a gift certificate as opposed to a gift card.
You seem to be trying very hard to exclude various kinds of products. Why is that? Why not just say, okay, they're all included? That's good.
Well, I think, Your Honor, that when Congress uses, to go back to the language of the statute, when it says money orders, traveler's checks, or similar written instruments, it's referring to two things that had traveler's checks and money orders that had understandings in 1974 that we can rely on. And by using that terminology and using those two instruments as an example, other similar written instruments must share some of the core characteristics of what those two instruments share, so I think Congress decided to limit it. On one point of agreement is I think it's probably true, and the American Bankers Association says this as well, if Congress wanted to include cashier's checks, classic cashier's checks, it probably would have said that. It knew what that instrument was. They were well-known instruments at the time, but they didn't present the windfall problem because, again, addresses were kept typically for cashier's checks just as they are today.
I assume that gift cards don't escheat, even if they fall outside of the FDA, as you say. They're not subject to the common law rule of escheat, are they? So that does anyone get them? I thought the reason why stores like them is because a lot of times people don't use them and they just get to keep the money.
I think, Your Honor, there's been a development over time in the law as states have realized that there are these things out there that certain states have passed statutes. I don't believe that all states have, and I think Arkansas does not have such a statute, but I think it's just been a development as these things have become more popular.
Can I ask you a question that kind of goes sideways? In places in your brief you indicate that you're after not just a declaration of rights here under the Disposition Act, but you actually want money damages for past wrongful takings of monies you think belong to your states. What is the cause of action that permits that? Is that an implied cause of action under the Disposition Act? I'm just curious if we were to agree with you, what happens next and on what theory?
So I think it is an implied cause of action under the statute, but I would add that we have not litigated the damages issue or the question. Those kinds of arguments haven't been presented to Judge LaValle because the parties agreed to bifurcate the proceedings here. So we haven't addressed any of the damages issues. But as for things I know Delaware discusses in its brief, the possibility that it could need to repay this money. But what I would highlight is, anytime we're dealing with unclaimed property, the state is essentially holding it in trust. It's not the state of Delaware's money. It's not really our state's money. We hold it in trust for the true owners. So requiring it to pay that money to the appropriate state, which will hold it in trust for the actual owners, Delaware really doesn't have any reliance interest there that would be upset.
But whether there's such an implied cause of action under the Disposition Act would be something that the special master would have to resolve after this. For
the damages issue, yes, Your Honor. I think that's something that could be resolved. Thank you. There's one other point or a couple of points I wanted to briefly address. I mentioned briefly the bank check thing, but I want to make sure I make this clear. Delaware's definition of a third-party bank check, setting aside whether an issuer or processor could be a third party in 1974, and it can't for the reasons the experts explain. But these instruments don't even meet Delaware's own definition of a bank check. So Delaware says that in order to be a third-party bank check, something must first be a bank check. As I mentioned earlier when we were discussing teller's checks, a bank check, and this is really, you've only been offered two sort of reasonable readings of what that term meant in the 1970s or even today, one of which I'll call this sort of technical definition. This is at page 37 of their exceptions, where they say that a bank check is an instrument that's signed by a bank officer, and as I said before, they stopped reading at that point, but it actually says drawing on funds deposited in the officer's own bank, that's a classic cashier's check, or drawing on funds of the officer's bank deposited in another financial institution. That's a classic or traditional teller's check. Again, that does not describe these instruments here. When the bank officer signs, one, he's signing as an agent of MoneyGram. To the extent that's not already obvious as a functional matter, the contracts between MoneyGram and the financial institutions make very clear. The financial institution is an agent of MoneyGram. So these instruments don't meet that definition because he's not signing to draw on any funds that are in control of the selling bank. Instead, it's MoneyGram that has the money, and it's MoneyGram that is responsible for paying the drawee bank or for reporting the unclaimed property. The other definition of bank check that you've been given is a broader definition than that, and it's the definition that Brady's Law of Bank Checks, which is again reproduced in Delaware's appendix, gives for bank checks, where it describes a bank check as both that technical definition that I just mentioned, but also ordinary checks. Or in the 1970s, going all the way back until World War I, bank check had been used as a term under Brady's Law of Bank Checks to both mean those specific instruments issued by banks, but also ordinary checks, and that's part of why a third-party bank check, ultimately, what that phrase means, if we're in the similar written instrument provision, is an ordinary check.
The impression I got reading your arguments and your friend's argument is that nobody has much of an idea what a third-party bank check is. Is that a fair?
That's fair, Your Honor. I think that we are, however, stuck with two things. We have to at least try and figure out what the terminology could have meant using similar phraseology in the 1970s. And, you know, again, they've agreed that it has to at least be a bank check, and we're in agreement there. Something must at least be a bank check, and these don't meet that definition. But in terms of what the entire phrase could have meant, again, this is another example where I think you've only been offered two realistic options based in the way similar phraseology was used in the 1970s, neither one of which would describe these instruments. So Delaware says that in the phrase third-party bank check, the third party refers to an outside issuer or payer. The problem with that is that that's not the way third party is used on a financial instrument. It wasn't used that way in the 1970s. All the experts agreed on that. Instead, when somebody referred to the third party on a check or third party in a financial instrument, that third party reference was always a reference to a payee or the party that ultimately got paid on an instrument. So sometimes, for instance, it was used like in the twice endorsed check definition, where third party check is a common enough phrase then and today that it's actually defined in Black's Law Dictionary as a twice endorsed check. So the third party on that instrument is the endorsee, the third party to the original transaction who's the payee on that instrument. The other way the phrase third party and check got used in the 1970s was in the context of third party payment services or third party services. And there again, the reference was always to the party that ultimately got paid, the payee. So a third party payment service, as the Hunt Commission explained, but it's not the only example, is a mechanism whereby a deposit intermediary transfers funds to a third party payee, a third party account holder, upon the orders of the depositor. So again, there, that phraseology is used to reference the ultimate payee. It's never been used, and Delaware doesn't cite a single source where it was used in the 1970s to refer to an outside issuer or processor. And what that means is they've offered a definition that is no way anchored with the way the terminology was used in the 1970s.
And don't we also have the legislative history that suggests that the inclusion of third-party bank check was supposed to be a technical or minor change? The thing that is a little concerning to me is that if it is used to exclude instruments that function like money orders, then we're talking about a huge carve-out to a statute that was designed to solve the inequitable escheatment problem in a way that doesn't seem technical or minor.
I absolutely agree with that, Your Honor. That Treasury, when it requested this, and it's undisputed, yes, it's legislative history in some sense, but it's really drafting history. Nobody disputes that Treasury requested this exception. And Treasury characterized it as a clarifying amendment that was designed to cure an ambiguity in the statute, which suggests that it was sort of the narrow change to the statute to make something doubly clear. And I think defining a third-party bank check as an ordinary check really fits that characterization of a clarifying amendment and a narrow sort of belt and suspenders approach to make sure that ordinary checks, which obviously do not present the windfall problem because, one, we have addresses because we have account information, right, but also aren't prepaid. So that is entirely consistent with that sort of legislative history.
I guess they failed in that endeavor to make things doubly clear.
So the generous version of this, I think, Your Honor, is that the way the phraseology was just sort of used at the time. You know, we're sitting here 50 years on, and you know, banking regulators have their own terminology. But the thing that I would emphasize is that, you know, third-party payment was, in fact, is pointed out at Arkansas's appendix at 177, so common that the Washington Post said that a third-party payment today means essentially a checking account. So that was ordinary phraseology that maybe has gone by the wayside, but it is phraseology that was used at the time.
Your argument is that in 1974, everybody would have known what a third-party bank check means? I actually do remember 1974.
I think banking regulators might have known what it meant, maybe not ordinary people, but...
Thank you, counsel. Justice Thomas, anything further?
Do you think we do more harm or less harm if we take the special master's suggestion that we decide this case without adopting a firm definition of money order?
So
that's what he tried to do, correct?
Correct. I think, Your Honor, that Judge LaValle's approach made sense in that under any ordinary understanding of the term money order, as the sources, Delaware sources, again, the ABA report on money orders from the late 1950s, the Compton's Encyclopedia define money order. It includes instruments sold by financial institutions, not in low dollar amounts. And it includes instruments like the agent check money order here. And I think that is when Congress adopted the term money order.
You haven't answered my question.
I think that it meets any ordinary definition. So I don't think that it does any harm to define it that way. I know we started with a parade of horribles, for instance.
Do we do less parade of horribles if we define it your way? Because you take care of cashier's checks and I presume certified checks by calling them a prepaid draft, correct?
Correct. The reason why I struggle with this is I think both things are neither one does that much harm, because again, they're alluding to this possibility of a parade of horribles, but they don't point to anything that would present that parade of horribles. You know, cashier's checks, even if
you waited how long to sue? They're afraid of all the guys who are going to come and sue now. And they have good reason to worry, because once we write a decision, the world will have the roadmap.
So what I would say to that, Your Honor, is that at least outside of the context of this case, I'm not aware of a situation where they allude, for instance, to private realtors, not to states having brought suits over cashier's checks. And even in those cases, nobody that I'm aware of is arguing that a cashier's check is a money order. Instead, those cases are all about the similar written instruments clause. But either way, I don't think that our definition, as I started by saying, necessarily requires treating them that way. I think they're well-known instruments, and if Congress had intended to include them, it probably would have used that language because they were well-known instruments at the time, and they just don't fit what Congress describes in 2501 as a money order, because they're not instruments for which addresses weren't kept as a business practice.
Thank you.
Justice Kagan? Gorsuch? No? Justice Barrett? Justice Jackson?
One final question. So Justice Kagan pointed out that Congress might have been intending to cover the field with this statute. And I guess my question is, so what is the field? It seems as though your friend says that really Congress was worried about no addresses, and as a result, large money instruments wouldn't fit in the statute because there was an incentive to have addresses. And I understood you to be focusing on Congress's concern about inequitable escheatment, in which case these instruments would be covered. So can you just, as a final word here, talk about what the purpose of this statute is?
Well, I'll start with the purpose of the statute is to address those instruments that presented the windfall inequity problem associated with the court's common law rule. I think what they're suggesting is there would be an incentive to keep addresses for larger dollar instruments. However, this case is a prime example of that hasn't happened. These are larger dollar instruments, and MoneyGram does not keep addresses. And it's the point here is that it's the issuer. It's the party that is actually responsible for paying these instruments. It's the party that holds the unclaimed property, and it hasn't kept those address information. So, I mean, to the extent Delaware is suggesting that somehow makes a difference here, the record just doesn't bear that out. But again, going back to the other point about, Congress's actual concern was not just the low dollar instruments. Congress's concern was that requiring addresses to be kept for money orders as a class of instruments and other similar written instruments would be an additional burden that is not justified in light of the fact that people buy these instruments where they do their banking. They buy them in their home state. So if you required addresses and all the burdens that go along with that, it's simply going to reflect the same place. So what Congress is saying in 2501 is, to use Learned Hand's phrase, the game is not worth the candle here. Congress just decided it was easier just to have these instruments that sheet to the state of purchase, regardless of what their value would be.
Thank you.
Thank you, counsel. Rebuttal, Mr. Katyal.
Thank you, Mr. Chief Justice. 5 points. First, as the Chief Justice said, they can solve this problem easily by saying MoneyGram has to have the information. The information's already being collected by the banks. The only question is closing that informational hiccup, and that's a lot better, Justice Sotomayor, than the instrument-by-instrument litigation that will be invited by their approach. His answer to that was to say, to the Chief Justice was, well, Congress put its thumb on the scale. They did with respect to those two instruments. The question in this case is, did they do so for anything more than that? And the reasons why Congress isolated those two instruments don't apply here. The other point is, Congress is the solution to this, even if you don't think states will have this easy fix, which I can't understand to this day why they haven't done it, but Congress can, of course, do that. That's what you said in the Delaware case in 1993. If you're worried about equity concerns, Congress should fix it. And what did you point to in that decision? You literally pointed to 2503 and said, that's the solution if you're worried about equity concerns. Second, with respect to third-party banks, my friend says that there's no expert testimony that supports our position. That's a misreading of the record. The expert, Ron Mann, just didn't support our position on the words directly liable. Back down below, as this case comes to the court, we agree Professor Mann was wrong with that. But with the definition of third-party bank check, I think, Mr. Chief Justice, you said, well, nobody really knows what it means. We actually think the Hunt Commission does know what it means, and they told you what it means in that report, and that says teller's checks are included. Now, my friend says, this is our third point, that cashiers and certified checks are different. Well, first of all, note that he doesn't disclaim them. He says, well, we're not necessarily saying it. There's already litigation about cashier's checks and certified checks, as the ABA brief points out. There have been key TAM lawsuits that have been filed. He says, well, cashier's checks aren't prepaid. Most cashiers and certified checks are prepaid. The only ones that aren't prepaid are the ones in which banks are paying their own expenses. And our brief explains why we think those types of checks are covered under the statute. Fourth thing, Justice Sotomayor, you had said, or excuse me, Justice Jackson, you had said the question in this case is, what is the field that Congress occupied? Congress knew exactly how to write the statute they want. They had the 1966 example. They didn't do that here. They wrote a much more narrow statute. And if you define, Justice Jackson, a money order as anything that transmits money that is prepaid, you blow up the statute. It means you can't explain what traveler's checks means. You can't explain what is left for other similar written instruments. Everything would be a money order. Nothing would be similar to it. And that's why Congress, and we think you should look to the rationales behind what Congress did. You pointed to the legislative history in the Treasury Department, but the Treasury Department just says essentially that this is a belt and suspenders fix. It doesn't say that something like teller's checks, which the Hunt Commission defined as being a third-party payment system, wouldn't be included. And finally and last, if you adopt our solution, the common law, it incentivizes exactly the kind of concerns that Justice Alito is worried about in Yee. It avoids any questions about these other instruments, from gift cards to cashier's checks to bearer's bonds and the like, and it avoids threatening the common law primary rule, because a primary rule is creditor addresses. And Justice Thomas, your opinion in Delaware said that has venerable old roots going all the way back to Old England. If they win, forget about place of incorporation. If they win, the primary rule of the FDA will control, which is to move away from last creditor's addresses. That is something that there's been zero support that my friend has offered on the other side for, and that's why that old presumption that you read statutes to avoid derogation of the common law has special force here. We don't doubt, can you read the statute the way my friend does? You can. But if you do so, it doesn't make sense of the statute and threatens all sorts of other financial instruments. And as the ABA says, that's something you should be really, really concerned about in this unique area, particularly because, as Justice Sotomayor points out, This litigation can go all the way back to 1974 and unwind not just the two disputed instruments here, but every other financial instrument. The safe thing to do is what you've done in case after case, which is to say, if we're concerned about equity, that